Good morning. Good morning, everyone. Good morning, Advocate Maema.
Good morning, Chairperson.
Advocate Chauke, good morning. Advocate Maema, you proceed with your evidence under oath.
That is correct, Chairperson.
Thank you. Advocate Ngcukaitobi.
Thank you, Madam Chair. Madam Chair, in the last 5 minutes, there has been some progress because what has been in dispute has now been accepted that is no longer in dispute about the contents of the dockets that have been analyzed. We analyzed 7 yesterday. We had to make a decision whether to analyze more. My learned friend tells me that they will not be placing that material in dispute anymore. But perhaps he should speak for himself.
Advocate Mchene,
Yeah,
on behalf of the evidence leaders.
Yes, Madam Chair, we have discussed it with Advocate Mahlomayane, and Madam Chair, we will not be disputing the contents of the dockets, those that have been analyzed and those that have not been analyzed. We accept that the contents of those documents are as they are, and the panel can take notice of them.
I do not know whether the NPA team would like to say anything. Please come forward to, you can borrow us that moving mic.
Thank you, Madam Chair. We're saying that not at this stage.
What do you mean, not at this stage?
That the dockets that are remaining would be contested.
Shouldn't you make up your mind? Because it will make it difficult for them to make an assessment whether it is important to proceed with the remaining part of the dockets, particularly because they may plan to deal with the different matter, and this witness may be excused sooner than we had anticipated.
As of yesterday afternoon, the discussion with the evidence leaders was that perhaps they should request a list of issues that the Advocate Chauke's team intended to lead evidence on, so that the team can decide whether they would need to have that proceeded with or that they accept the contents as they are and they will not dispute anything in relation thereto. So when the discussions were made, there was no indication whether there will be an agreement on that aspect. So matters were left at that.
Were you part of the discussion 5 minutes ago?
No, I was not part of the discussion 5 minutes ago.
Yes, I appreciate that your senior Advocate Halley is not here.
Yes.
I'm just affording you this opportunity because you are representing the NPA, and it doesn't appear to me that there can really be any dispute because the dockets are what they are as they stand, unless of course you're going to call evidence to the contrary.
Thank you, Madam Chair. Unless perhaps I get just quick instructions from my senior and client. But as I say, the indication was that at least if we get pointers of issues that they still needed to lead evidence on, and the team would decide whether they want to accept and admit the evidence as it is.
Can I just check? You do have copies of the dockets?
Yes. Yes.
And we got the dockets from NPA.
Yes. Yes.
Obviously, you would have gone through them.
Yes.
And you would have identified issues that you dispute
Yes.
from the dockets.
Yes.
So maybe instead of having the Chauke team that is now in the process of leading evidence, having to make time to write down all the issues that they intend to lead, because obviously if they have 28 dockets, they would intend to lead evidence on 28 dockets. But it would be better if the NPA were to say in docket, in count, docket number, case, whatever, we dispute 1, 2, 3. And yeah, because the documents are yours, they come from you. So you should know them better than us. I take it, maybe it would be better if you were to still persist that you are going to oppose some of the issues. Maybe you should just alert the Chauke team so that they deal with it, and we obviate the need to have to recall a witness or to have to revisit any evidence. Thank you, Chair.
Thank you, my sister. Yes, I agree. And but for now, we will proceed on the basis of your for now.
Yes.
With the view that you will revert. You understand why we are here.
Yes, I do, Madam Chair, and I appreciate that if we can proceed on the basis that at this stage at least there is no indication on what we are going to need further evidence to be led on and be allowed later on to indicate.
The affidavit of Mr. Maema is in front of you.
Yes.
You know exactly what he's saying about those dockets.
Yes.
If there's any issue that arises from those aspects that he's raising in his affidavit, which we now have, all of us have read, you should be in a better position to say to Advocate Ngcukaitobi, we will dispute this and that, so that then he can focus.
That is so, Madam Chair. We will do that.
Yes, thank you. Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Maema, good morning. We will...
Let me remind him that he is under oath. I beg your pardon, Advocate Ngcukaitobi. Counsel, you are still under oath.
That is correct, Chairperson. Thank you.
Thank you, Madam Chair. We will
Good morning,
skip,
Chairperson.
yes, we will skip everything from the last case that we dealt with, which was the case of Peggy Temba, to paragraph 345.
I am there, Chairperson.
Yes, the heading there is Legal Framework for Racketeering.
That is correct, Chairperson.
Yes. Now, the a number of concepts that one needs to dissect in dealing with the concept of racketeering. The first one is the concept of an enterprise.
That is correct, Chairperson.
Can you explain why you believed the Keitomano unit qualifies as an enterprise under the poker legislation?
Chairperson, the concept of an enterprise, I deal with it on page 1-86, paragraph 350.3. An enterprise in terms of the poker legislation is defined to include any individual partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated in fact, although not a juristic person or a legal entity. So the enterprise is that common vehicle through which all the offences are committed, but it is the members of the enterprise might differ from incident to incident, but the fact is the enterprise advances the objectives of the enterprise.
Yes. Now, there is also an associated topic around the concept of an enterprise, which is whether or not it's necessary in law to qualify as an enterprise, that it must be performing illegal or unlawful acts. Remember that the finding made by the DCOG panel is that Ketomano is not an enterprise because it was established for lawful purposes.
Well, Chairperson, you find an institution established for lawful purposes, which is just a cover. But when in real fact, there are other businesses that they engage in which attract criminality. So whether it is a lawful institution or an unlawful institution, it can be an enterprise.
Yes. Then there is also another element to it, which is who is inside the enterprise.
Yes.
And how do you decide who is inside the enterprise? Can you explain to the panel how is that exercise to be undertaken?
Well, you look at the day-to-day activities of the enterprise. Like you say, Council, the members of the enterprise on any given incident might be different. But whenever an individual participates in the activities of an enterprise and advances the objectives of the enterprise, then he associates in fact with the enterprise.
Yes.
So you can charge him as part of the enterprise.
Yes. Thank you. Now, just to apply then these concepts of an enterprise to Ketomano
Yes.
specifically, can you help us with that?
Chairperson, we as a team, as a prosecution team, my team, together with the police, the DPCI, and IPED, as well as Advocate Musing from National Office, we spent, I think, almost a week debating this issue of an enterprise. When one looks at the provincial organized crime, we thought, particularly because of the involvement of General Johan Boysen at provincial level, we thought, could the entire provincial organized crime be an enterprise? But when you looked at the role of Colonel Aya, who was then removed, and then Boysen comes down from province to assume the position of Aya, and the serious violent crime section of Ketomena is the one that conducts all these activities. Then we concluded that the serious violent crime section in Ketomena is actually the enterprise. And because Johan Boysen managed their activities, supported them, and made sure of their continuity, we then settled for serious violent crime based at Ketomena as the enterprise.
Yes. So the one way of looking at it, so what happens, for instance, there are some sins that I've noticed here where the members of the National Intervention Unit come and play a role.
That is correct.
Yes. And then there are also some scenes where you'll find a member from, we looked at one 2 days ago, from Kranskop.
Yes.
comes to the scene, and then Cato Manu comes and they remove them.
Yes.
So although you've got in total 28 of these incidents,
Yes.
23 of the incidents, 28 deceased, it expands and contracts by the addition of people from outside of Cato Manu.
That is correct.
Just explain that. How does one deal with that?
You see, for one to be part of the enterprise, you must participate in two or more incidents. So in some of the incidents, we find one or two who participates in one or two. But we to be charged with 21E or 21F, we needed a member of the enterprise to participate in more than one incident.
Yes.
Yeah. So those that we charged with 21E and 21F, we are convinced that they had a role in more than one incident.
No, we'll come to the participants
Oh.
because that's a different topic. I'm still trying to understand the enterprise itself, how you saw it. So you say that the inner core of this enterprise was the Serious and Violent Crime Unit of Cato Manu.
That is correct.
And we know the members of that unit.
Yes.
Yes. But I'm saying sometimes if there is someone from outside of that unit,
Oh, now I get you. Yes. Who then comes?
Yes.
Then you look at the role of that person.
yes,
And how the role of that person, what do you say, advances the objectives of the enterprise.
yes,
Yes. Yeah. And if whatever role that he participated in advances the role of the enterprise, then you can charge him.
yes. So, but how would you know that his participation? Because you see, if you said, listen, my enterprise is this group of people,
Yes.
because they are pursuing a same object over a sustained period of time.
That is correct. Yes.
But now there's someone from outside who comes in on one or two occasions. You say, well, that doesn't change the character of the enterprise. I suppose.
That is true. Yes. So what you do is you then charge him with the role that he played, not in terms of 21E or 21F, but as you specifically include him in the incident where he was
I
physically
see.
involved.
So that would not be a racketeering charge.
That would not be a racketeering charge. Yes, it would be a predicate offence.
Because the racketeering charge requires that enterprise to be
That is
defined.
correct. Yes.
So if you charge someone who came from NIU or NIT, it will be because they've committed murder.
Yes, they were present at the particular scene where one of the deceased was killed.
But not because they were in the racket.
Not that they were in the racket. That is correct, Chairperson.
In that event, he could be charged under the common purpose principle.
That is correct, Chairperson. Yes.
Yes. Thank you very much. Now, all right. Is there anything you want to add on the definition of an enterprise and why you believed it applied to the Serious and Violent Crime Unit of Cato Manu?
Chairperson, I think we have dealt with it, yes, sufficiently.
All right. Thank you.
Thank you.
There are further concepts that must also be dissected. The first one you deal with in 350.1, pattern of racketeering. Just explain the concept. We will deal later with how it applied to Cato Manu.
Chairperson, in terms of Section 1, a pattern of racketeering activity is defined as the planned, ongoing, continuous, or repeated participation or involvement in any offence referred to in Schedule 1, and it includes at least two offences referred to in Schedule 1, of which one offence occurred after the commencement of this Act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such a prior offence referred to in Schedule 1. So the pattern of racketeering activity would look at those the commonality in all the incidents. When you say, for instance, in Cato Manu, one thing that is common in most of the incidents is raiding early morning when people are asleep, but predominantly one similar character in the manner of their conduct is planting of a firearm, placing a firearm at a place where the deceased is killed to create that threat threat impression. You'll remember at one of the incidents when they were in the Kumbi, Moster ran back to the Kumbi during the raid to go and get his Bombay, because the Bombay is an essential element of the pattern of racketeering activity.
You know,
After
I thought
the
of this
shooting,
word Bombay yesterday. In the townships, it's used to indicate something fake.
yes,
But in the villages, it's actually not Bombay, it's Mbai, which is a machine gun.
yes.
Anyway, I thought, so it's actually Mbai.
Yes, but you see the Ketomena guys refer to it as Bombay.
Yes.
Because what it signifies is a spook,
Yes.
something that was not there, but that is there.
Oh, I
So
see.
it wasn't there during the commission of the offense, but it just suddenly appears. So
it
they
was
make
used
it
properly
appear
as fake.
as fake. They
Oh,
make it
okay.
as fake. That's how we understood their concept of Bombay.
Oh, okay,
To
so
me,
it's the
yes.
Bombay gun.
It's a Bombay.
It's a
gun.
pretend gun.
Pretend, yes. It wasn't there, but it's there.
Okay. No, I understand. All right, but let's just come back then to this concept of a pattern. So you say there has to be a similarity in the activities of the group that is
Yes.
participating in the enterprise.
Yes.
And you've identified two similarities, but we'll come back to those. But I just want to come back to the words of the statute. So the first one is the planned.
Planned, yes.
Yes, let's just talk about that. What does that entail?
Well, planning it's a concept that we have in conspiracy. The coming together of individuals planning to achieve a particular objective. So there must be some coming together of minds. We come together and we plan and we say, this is what we hoping to achieve.
And why do you say that there was planning in respect of the SVC of Keetoman?
Chairperson, there was planning. They have to ensure that they have vehicles, they have equipment, they are able to execute, and yeah, there was a higher degree of planning in the activities of Keetoman.
Yes. And that's exhibited by the degree of organization in the way in which the executions took place.
That is correct. If you look at consistently most of the scenes, Eva would consistently be used to work on the scenes and to clean the scenes up. And there is a penetration team.
Yes.
Penetration team is those that get to the door, they knock, and they we call them the scope and boboza. They break down the doors. Those are the experts. And we have one or two who are good in shootists, who excel in target shooting. If they want to shoot your ear, they will shoot your ear. If they want to shoot your fingers that are holding the gun on the holster, they will do that. So there is a particular plane, and there is particular individuals that are given specific roles that they must execute.
Yes.
Yes.
I mean, I suppose even the concept of planting a firearm, that's not a random thing. That
It's not a
also
random.
is part
Yes.
of the.
It's part of the plane, because there you see Moster running back to the Kumbi. Underneath the driver's seat of the Kumbi, there is a bag containing firearms, and he picks one there and he goes to the scene and he throws it on the scene.
What about the identification of the targets to be executed? Is that part of the plan?
It is part of the plan, Chairperson. It started when they came back from Kranskop.
Yes.
Yes. Because after Reddy was killed, there were two that were killed prior to Kongo.
Yes.
And after Congo, they said, no, it's enough. We're not going to let criminals in KZN take over the province. We will deal with them, and we will deal with them decisively.
Yes.
So the plan started just after the killing of Congo. They said criminals are not going to take over in KZN. But it is right for the police to say criminals can't take over. Yes, but what do? You make sure that you collect evidence lawfully in terms of the Constitution, you present the evidence before court, and you convict the criminals.
Now, I mean, you've said twice that this began after the murder of Superintendent Chauke.
Yes.
There is the evidence of Mr. Danikas, who traces the events from 2001.
Far earlier, yes. Yes.
Which was one of the pieces of evidence in front of you. What do you make of that?
Chairperson, we looked at that evidence, and in terms of poker, it is similar fact evidence that you can lead that is admissible. So even incidents that happened before, although we have a period that we focus on, but you can refer to a previous incident, you can refer to a previous conviction. This is one of the instances where even a previous conviction is allowed to be disclosed before conviction.
No, but I'm saying in terms of when this conduct of Kato Manu began, when you say it began after the murder of Superintendent Chauke, there is a witness who actually traces it earlier than the murder of Superintendent Chauke. I understand the issue of similar facts. We can deal with that later, but
yes.
For now I just want to deal with your point that the planning to execute, which we are still dealing with the concept of planning, the planning to execute took place after the murder of Superintendent Chauke. How do you place that in the context of what Mr. Danikas is saying, that actually we had been torturing and killing suspects since 2001?
That is correct. Chairperson, I'm saying it started early, but the tip of the iceberg was the killing of Supcon. Because what happens when it was happening prior to 2008 at a snail pace. After the death of Supcon, you see it picking momentum, and it not only picking up momentum, also the vigor and the enthusiasm, the rigorousness increases.
Yes. Thank you very much. Then you have the second word. It's planned. It's also ongoing. What does that refer to? Ongoing.
Ongoing says it must be. It must happen over. It mustn't start and then starts. That characteristics denotes that it's something that takes place over a period of time.
Yes. So in other words, it's not one incident of a policeman killing a suspect, but it's several incidents.
Several unending incidents. Yes.
And then those words appear to be similar to continuous or repeated, which is also in the statute.
Yes.
Can you just explain what, I mean, because ongoing, continuous appear to be meaning the same thing, and repeated also seems to be meaning the same thing.
Yeah. Well, all that they denote is that it's like an object falling from the mountain. It just keeps on rolling. So it is incident after incident after incident. So they are continuous, repeated, ongoing. Yes.
Now I want to ask you here, because there are some findings made in the DCOC report which are in conflict with your approach. Finding one is that continuous means it must be unending into the future. So in other words, you can't say it was continuous between 2008 and 2011, which was the scope of your indictment. It must also be continuous beyond 2011, way into the future. Now, what do you say to that?
No, it is an incorrect analysis of the principles, because what would happen, although it is ongoing, continuous and repeated, something will happen that will apply brakes to this object that is rolling down. If it hits a rock and gets stuck, or if the car that is going, the petrol finishes, then at some stage it comes to an end. But the mere coming to an end of an operation, that does not mean it disqualifies it from.
Yes. Are there
from
also not
from the characteristics?
yes, serious implications of their finding, which is if a person or a group of persons who constitute an enterprise commit acts of racketeering between 2005 and 2010 and they stop, maybe the leader of the enterprise is killed.
Yes.
The NPA then comes in 2011. On this concept that it must be continuous into the future, what would happen?
Then it would mean you disqualify yourself from dealing with that as an enterprise.
Yes.
So it doesn't make sense.
Yes.
Yes.
Yes. Now, is there anything to be added on the word repeated? We've dealt with continuous.
Repeated also, it's the same, over and over again, thing happening over and over again.
Yes. Now, is there anything you want to add on continuous, ongoing, and repeated in relation specifically to Cato Manu that you haven't said?
No, Chairperson. What we saw their conduct fitting the definition of a pattern of racketeering activity as defined in poker. And this was a debate that we had amongst deputies, among senior state advocates, amongst General Mabula, Mr. Engas. Although the concepts themselves are not very. The police do not speak this concept. Prosecutors also do not speak this concept. I can assure you that if you go to the management of NPA, where Mr. Chauke was part, and say, define some of these things, they will not be able to, because they are not people that are working day to day with this kind of things. The people that are working day to day are organized crime prosecutors within DPP offices.
Yes.
If I may, on that, it means finally, when all is done and the matter is in the court, it's a matter for interpretation by the court.
Chairperson.
Applying the law to the facts?
Yes. Chairperson, what happens, we say, well, at the law school they talk about the art of persuasion. So I take my understanding of racketeering and the principles, and then I must convince my judge to see it the way I see it. I must persuade my presiding officer to see the facts the way I see them, and to apply the law in the manner that I want, that I see should be applied.
Yes.
And in relation to these matters, that will be more of the case in the criminal prosecution?
That is correct, Chairperson, yes.
One of the conclusions by the DCOC team is that if indeed there was racketeering towards 2012 or 2011, the number of people killed went down, so that indicated that the enterprise is dying, and therefore there is no need to continue with racketeering charges. I may not be quoting it verbatim, but I know that that is one of the conclusions that they came to.
I remember so, Chairperson, yes.
Is that the correct conclusion?
That is not a correct analysis of the principle. I differ from it with the greatest of respects.
I think my junior will find that portion, but it's exactly as you remember, Madam
Yes.
Baloimer. Yes, yes. Well, explain why you differ. That's the point of the question.
Chairperson, the fact that crime goes down, or the regularity of the occurrences just go down a bit, is not an indication of the conclusion or the non-existence anymore of the enterprise, because all that the law requires is, let's have one or more incidents that are continuing, that are ongoing. If I have one or two incidents that are, no, not one, two or more, that are continuous, that have a pattern, that are repeated, then I'm squarely within the definition in poker, and I'm fully entitled to proceed on a racketeering charge.
Yes, the passage that is relevant. I'm not sure if the Cook report is in your bundle. It's not. Okay. I just wanted to be brought to your attention so that I can reference specifically paragraph 190.6, which is page 69 of the Cook report.
In Chairperson, in which file do we find the Dikok report?
I think just use mine. I've got two.
Thank you.
Yes, Madam Chair, I'm not sure where the panel has it.
We have those loose ones, but they are lying somewhere. We will find that. You can go straight to the paragraphs.
Yes. Thank you, Madam Chair. So if you go to page 69 of the report, the pages are at the bottom left.
I see them, Chairperson.
Paragraph 190.6. Can you just read that for the record?
Paragraph 190.6.
Yes.
If one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific thread of repetition extending indefinitely into the future.
Yes,
Yes,
that's the question you have to answer. Why are they wrong there?
Chairperson, when you look at and that's in my view just basic interpretation of statutes by Cochrane. When you look at the entire tenure of the legislation, the entire legislation, it is intended to prevent organized crime, the perpetuation of organized crime. Now, when for one reason or another, the crime stats goes down, you cannot say, well, because the fancy boys are no longer committing offenses as regular as they used to do. Now I'm not charging them with racketeering. So the regularity or the extent of commission of these offenses does not necessarily mean you have reached your goals. So even if the specific threat of repetition does not extend indefinitely.
Yeah.
The fact remains, the offences are being continued. So my view would be that even though the continuity of the Racketeering Acts are subsiding and not continue indefinitely, it still fits the definition of the definition that we find in the legislation.
No, but I mean, assume for the benefit of the Dukok panel, the best argument they can put up, right, is that the racketeering has ended. Assume the evidence is that it's ended. The enterprise came to an end. So if the enterprise was a gang called the Fancy Boys,
Yes.
the Fancy Boys were all killed,
Yes.
right, and or the leaders were killed. The question is, can the NPA say, we are charging you because for 10 years you were engaged in racketeering, for those who survived, those members of the Fancy Boys who survived? Even though
Perfectly.
it's ended.
Perfectly, the NPA can still, because it is elimination of crime that you are focusing on.
Yes. And this is the point about the Dukok panel saying it must extend indefinitely into the future.
Cannot be,
Yes.
because
After you may proceed
Because-
to elaborate.
Chairperson, what I was going to say is, for the members of the deceased families of those incidents that have occurred, if you say in 2012 there is no other incident, what do you tell them? Because you should be able to give them an answer. So accountability in terms of the legislation, insofar as my view, the analysis that is in the Dukok report with respect is incorrect.
I suppose, as you correctly put it, it's also the matter of interpretation. You have to look at the intended purpose of poker, first thing, not so. And I don't know whether you have the same thing in Xhosa or Zulu, Advocate Ngcukaitobi. In Setswana, we will say, Molato ga o bole.
Yes, of course we do.
You have committed these crimes 10 years ago and stopped committing them, but that crime remains.
It remains.
It doesn't get rotten and to say, I'm no longer going to prosecute. That's why we say, Molato ga o bole.
That is correct, Chairperson. Even that rape victim some 15 years ago in the adulthood still remembers that I had gone through this experience that no one is supposed to be exposed to. So Molato ga o bole, definitely we as a NPA, constitutionally we should pursue all molatos, all offences we should pursue.
Yes. It's called
Without-
Ityala Alboli.
Without fear, favor, or prejudice. Yes, Chairperson, Ityala alboli.
Yes.
What do you say, Advocate Ngcukaitobi?
It's called Ityala Aliboli.
Ichala aliboli.
Yes.
Yes,
So it's the same
the
thing.
same as Molato ga o bole.
The person who should be told that is the current NDPP. Gladly think that he doesn't have to deal with this.
I suppose he's a Motswana, he knows that.
Oh, okay.
So I don't know, but I'm sure he understands that.
Thank you. Maybe you should just keep the panel report because at some point we'll come back to it. Now,
Thank
just
you.
to back to the definition. So it's planned, ongoing, continuous, or repeated. And then there's another term, participation or involvement. So the legislation requires that you participate actually
Yes.
or you are involved.
Yes.
What does that mean?
You see, Chairperson, poker was directly aimed at those people who do not participate, who are seen no way, but who fund these terrorist activities. So you fund and but you are never on the scene. But you make it possible for this for this kind of offences to be committed. So you don't necessarily have to participate, You can participate physically and be there, but even those that get involved indirectly, in a way of funding, in a way of supporting, in a way of encouraging, they are included in the definition.
So it's the participants and the enablers.
That is correct, Chairperson. Yes.
Yes. In fact, that term is defined very crisply and powerfully by the Supreme Court of Appeal at paragraph 348 of your statement. If you just go up one page.
In S versus Asian,
Yes.
the Supreme Court of Appeal explained the difference between the two offenses. The essence of the offense in subsection E is that the accused must conduct or participate in the conduct of an enterprise. Actual participation is required, although it may be direct or indirect.
Yes. Then it continue that.
In that respect, the subsection differs from subsection F, the essence of which is that the accused must know or ought reasonably to have known that another person did so.
Yes.
Knowledge, not participation, is required.
Yes. So just to come back to the point we're making, that we are targeting actual participants,
Yes.
direct or indirect,
Yes.
but also enablers.
Enablers and those that do not participate physically,
Yes.
but who make it possible for those conducts to happen. So if you're looking at the fancy boys that are committing robberies, but there are traffic officers who are making sure that they travel safely. They, even when they have their loot, they make sure that they get safer and faster passage through the traffic. Those enablers you can still charge with racketeering.
Yes. So just go back then to Ketomano. This concept of being a participant or an enabler,
Yes.
that's what you call involvement.
Yes.
How do you apply it to those facts? I mean, the big name that we've been talking about, I'm not sure if it's a big name, but it's a common name. It's that of Major General Boysen.
Major General Boysen, in our view, managed the activities of the Ketomena. And, we have instances where he also participated.
Yes.
Yes. So for those incidents where he participated, there are those that he participated directly and those where he participated indirectly. But
how would he have participated indirectly on the facts we've seen?
Let's say let's look at the minimal, those incidences where he was not there.
Yes.
Because what he does is he makes sure that AIA is redundant. We remove AIA from there. We make sure that they have vehicles. We make sure that they have all the resources, and we make sure that they have the legal system or the police system works on the basis of informers.
Yes.
That are some of the people that you live within the communities that know that crime is being committed. So they make sure Ketomena was structured in such a way that they have an informer network that finds information. You know, even when Ndimande ran to the northwest, to Rustenburg, they were able to sniff and know that he is hiding somewhere in Rustenburg. Even though Makojela was hiding out in the Free State, when he came to Pietermaritzburg to collect money from his taxi operations, they had a strong informer network to know his movement and to be able to track and trace him wherever he goes.
Well, there's also the other element which we looked at last week, which is impunity.
Oh yes,
These were untouchables.
Untouchables. You know that when you do anything, nothing will come your way. You have protection.
Yes. And at a senior level, could he provide that protection?
General Boysen at the senior level was a cushion that they required to ensure the continuity of the activities.
Yes. Now, it says participation or involvement, and then in any offense referred to in Schedule 1,
That is correct.
and includes at least 2 offenses referred to in Schedule 1.
Yes.
And
So that's
what-
why I said you need 2 or more offences.
Yes. Now, this is Schedule 1 of poker,
That is correct.
or Schedule 1 of the Criminal Procedure Act.
No, it's Schedule 1. When it refers to a schedule, it's of the same legislation.
Yes. Now, I don't know if we have the Act here, but I think it's necessary to go through the offenses in the schedule.
Whilst you are looking for that, Advocate Maema, just for clarity, the Section 21E and read with 21A are not mutually exclusive.
No, they are not, Chairperson. Yeah.
They
Because
are not.
they are not mutually exclusive. Because the one is managing and the one is participation in the activities of an enterprise.
Computer.
So we see, we charged General Johan Boysen with both 21E and 21F.
Yes. Do you have, you don't have the schedule? Okay, I'll organize a computer to be put in front of you to go to Schedule 1.
Before you do that, Counsel, now as regards the Katomena predicate offences,
Yes, Chairperson.
in relation to this exclusivity that we're talking about,
Yes.
given that the racketeering charges were withdrawn
Yes, Chairperson.
by Advocate Batoyi,
Batoyi, yes.
and instructions was given that the DPP KZN should proceed with the predicate offences.
That is correct, Chair.
I suppose only in relation to the accused people, persons, who would have been listed in those specific dockets.
That is correct, Chairperson. Who would have actively participated in those, unless if on the basis of common purpose they can link somebody other than the one who was physically on the scene.
Yes, that's where I was going
Yes,
to. Yes. So if the prosecution team in the DPP KZN would then have found that the principle of common purpose kicks in,
Yes,
implicating also Major General Boysens,
yes,
given in one of the dockets where he was directly involved
that is correct, yes,
at the scene,
yes.
then he could be then charged under those predicate offences,
That is correct,
under
Chairperson.
the principle of common purpose.
That is correct, yes, yes.
Thank you, Madam Chair. Do you now have Schedule 1? Of poker?
Oh, do you have the schedule? Thank you. I do, Chairperson.
Yes. I mean, there are 34 offenses there.
That is correct, Chair.
Yes. Now, so are those the schedules that are referred to in the definition of a pattern of racketeering offenses?
That is correct, Chairperson. It's,
Yes.
Should I read the offense?
No, well, my learned friend just says to me that it's not necessary because we can take it to be common cause that that's the schedule.
Yes.
And what you need for poker is participation in 2 or more of those offences.
That is correct, Chairperson. Yes.
Thank you. So you may return the computer.
Thank you. It would be handy, though, to
To keep it.
to keep it and go home with it.
Thank you. Now,
Thank you, Chairperson.
so is the evidence that what you need to establish a pattern is a participation of an individual in 2 or more of those 34 offences?
That is correct, yes.
Yes. And then it says, of which one of the offences occurred after the commencement of this act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such prior offence referred to in Schedule 1. So what does this mean? That you've got a 10-year window to charge a person for racketeering?
That is correct, yes. 21E and 21F. Remember, it only deals with the racketeering offences,
Yes.
and not any predicate offences, if that would be murder or yes.
Yes. All right. So how would that apply to the current scenario? I suppose they were charged even if the charges were withdrawn. So they were charged within a 10-year window.
That is correct, Chairperson, yes. Yes.
Yes. Okay. Now, that takes us to paragraph 351. A distinction between section 21E and 21F. Can you just take us through those and the sub-paragraphs? 351.1 to 351.3.
Chairperson, at 351.1, the offence of racketeering under poker is distinct from and can be charged in addition to any underlying predicate offences that comprise a pattern of racketeering. I usually end at the pattern of racketeering activity, because that's where it ends. But here, pattern of racketeering. It is for this reason that the indictment in Ketomena included charges of racketeering and distinct and self-standing charges of predicate offences.
Just explain what that means when you say, because we debated this with Advocate, but she didn't really commit to a position either way, which is, what is the issue in this case that we are dealing with? Is it only poker or poker plus predicate offences? And then she kept on saying, well, the predicate offences are part and parcel of poker.
Well, the racketeering offences are count 1 and 2. They are self-standing. They are charges by themselves.
No, what I mean is this: in order to prove, in other words, to prove racketeering, you will have to prove the murder. If you are saying the predicate offence is the murder.
Yes.
Yes. That's the
So
point I'm making.
you will have to prove all the predicate offences, because by proving the predicate offences, then you will be proving that over a period of time, you will be showing that it is ongoing, continuous, repeated over a period of time. In that way, then you are now in the element of a pattern of racketeering activity.
So it's a bit misleading to say that this case is not about the predicate offences, because the case is about the predicate offences.
It is about the predicate offences.
Yes. Now, you were still at, sorry, I stopped you at...
Before I
yes,
start with the accordingly.
Yes, yes.
Accordingly, if an accused is not ultimately convicted of racketeering, it does not follow that he will not be convicted of the underlying predicate offences. So if your evidence before court would fall short, and the court would not be convinced that there is sufficient for racketeering, the court will still be at liberty to convict
So in
you
other words,
of
if a court
the
says
predicate offences.
you've committed murder once, but I cannot find that it was continuous,
Yes.
you are still guilty of murder.
You're still guilty of that kind of murder.
Yes. I mean, this is where one of the things I don't understand in this case, because they just withdrew everything.
Strange, very strange.
All right, 351.2.
351.2, Chairperson. Participation in the enterprise and management of enterprise are not mutually exclusive. That is the point that the Chairperson just asked me to elucidate on earlier. 351.2.1, Section 21E caters for a situation where an accused manages the enterprise and participates in a pattern of racketeering through which its affairs are conducted. But the emphasis there is manages the enterprise.
Yes, now, just to come back to this particular case, you had identified, I think, 5 managers.
That is correct, yes.
We can go through them because I need you to explain to the panel why those 5 individuals were identified as managers. They are
Chairperson, they are on GSM 1-22.
what page?
Page 1-22 of the statement.
Sorry, what paragraph?
Paragraph 71.
Yes, that sounds correct. Yes, that's where you've identified them. Just take us through each one of them and explain why they were the managers.
Chairperson, all of them except Van Tonder were section commanders.
It can't be all of them because Mr. Boysen was not a section commander.
And I was, no, it can't be all of them.
That's why I'm saying just take us one
individual.
individual.
All
Yes,
right.
yes.
Let's start at 71.1. Johan Boysen was the provincial commander of organized crime. But now, instead of being in the provincial office, he then removes Aya, who's the head of Devon organized crime, to whom Ketomena's serious violence unit has to report. He then becomes he assumes the role of Aya. So all of the section commanders then would then report to him, and he facilitates their activity by making sure that they have equipment that enable them to do their work. Now,
I mean, is there evidence that Aya was actually removed? What do you mean when you say he was removed?
he was rendered redundant.
Yes.
So although he was there as the head of Devon organized crime, they would jump him. They would jump him insofar as decisions and everything. When an incident would have happened, he would hear it on the radio. Unlike Johan Boysen, who would hear it from the members, from Olivier, and then attend the scene. But Aya would be the commander in name, but not in real fact.
So would you describe him as having been the de facto head?
As the de facto head, yes.
So that covers Major General Boysen.
Neville Eva was known for his attention to detail.
Yes.
So he would make sure that make sure that all the scenes are doctored in accordance with the wishes of the enterprise. He'll make sure that there is a firearm that is placed there. He'll make sure that on every operation there are members that would do the guarding of the scene,
Yes.
protect the outside, and there would be sufficient of the members of the penetrating team. The penetrating team, Chairperson, remember, are those that I said they are at the door and they identify themselves, and if you don't open as soon as possible, they will make sure that that door comes down and they enter.
So in that sense, he's playing a management role.
He's playing a management role to ensure that that happens. Now, Olivier was the one who was the head of serious violent crime.
Reported to
He's the one that was supposed to be reporting to Aya.
to Mr. Ayer, yes.
Yes. Now, instead of reporting to Aya, he reports to Johan Boysen. Lockham was also one of the commanders who also made sure that all the team members are available whenever they are required. Whenever there is information that comes from the informer of any of them, then he would make sure that whoever has to be on duty gets on duty, and he would ensure that they have a sufficient number of officials at that activity to deal with whatever challenges that comes out there.
The last one is Mr. Van Tonder.
Mr. Van Tonder was the one who was he's predominant in all the activities. He's the one who was mostly present in all of them. But he was a trusted soldier of Johan Boysen. Johan Boysen will trust him with all the information, and he will make sure that whatever activities that they have planned are executed to the satisfaction of the wishes of Johan Boysen.
Yes, okay. Thank you. So in that sense, these were playing a management role.
They were playing a very crucial management role of the activities of the enterprise.
It sounds like there were different facets, but nevertheless, it's management facets, because
That is correct, yes.
One is managing informers, one is managing the actual scenes, one is making sure that the logistics for operations are undertaken, and then there is the overall supervisor.
Yes. And the overall supervisor also ensures that you manage the, what do you call it? The reputation of this team, so that also insofar as the media is concerned, there is no negative reporting about Ketomena activities.
Yes.
You have your Karima Browns who will report negatively about Mr. Chauke and I in the media. You have all of that, that makes sure that. Yeah.
So who was responsible for making sure that you receive positive media coverage? The unit receives positive media coverage? I didn't get that.
No, I'm saying Johan Boysen would also make sure that the reputation of the Ketomena remains intact.
I see.
To ensure that there are those in the media houses that would report in accordance with the narrative that they were pushing. Your Karima Browns, there are a number of them. They are. I got the Coke report as a result of one of the media people asking me what my comments are. I've never received a copy from the NPA, and when I received it, then I make sure that I share it with the Advocate Chauke and most of the other teams that are referred to in the report. So very strange that a report that deals with the work that you've done within the NPA is not only the compilation thereof is not only shared with you, but up until finalization, I hear about it from the media.
Yes. Thank you.
But then why would you think that that information would have been given to the media by Major General Boysen?
Chairperson, I'm not saying it was given by Major General Boysen. All I'm saying was it's a report that was generated within the NPA about work that I have done myself. So they expected some stage to say, Maema, you're saying there's evidence. Where is this evidence? Show me. The dockets are here. Come show me where is this. Where is this? Particularly with the Rodney Dikok, who was very close to me. I had expected him to pick up a phone and confront me about anything. I would not go to Cape Town and leave Cape Town without visiting Rodney Dikok in Cape Town. So I would have expected if there is anything that is within the institution that affects the moving of his eyebrow, he can pick up a phone and say, Maema, what is happening here? Can we sit down here and talk about it? We could sit down and talk about anything and everything. But he compiles a report about this. There are things that I have done that he doesn't understand, that he finds strange, but he doesn't confront me with that. So I found that very strange.
So the disclosure could have been made by anyone within the NP Act.
That is correct, Chairperson. But all I'm saying is, Audi Alterem Patem says, you hear the other side. Now you compile a report like this where you rubbish the work that I've done, yet you don't give me an opportunity to explain the rubbish that I've done. So I would expect it at least to say, what is this thing? It doesn't make sense. Because as lawyers we differ, judges differ, but at least engage, hear the other side.
Maybe let's just talk about process and not about expectations because of the relationship that, that you have
with
or
him.
You had with him.
Yes.
When one reads this report, it appears like it's a product of a review of the work that was done by your
by my team. Yes.
That's right.
Chairperson.
Now, what is the process in the case where someone is in the NDPP, in particular, the NDPP herself or himself, whoever would be occupying the position?
Yes,
what is the process if someone wants to review the work that you have done?
Chairperson, if one looks at section 179 from subsection 2 to subsection 5, in fact the review powers of the NDPP are in section 179 sub 5. The review would be instigated by a written complaint or either a complaint from an accused person or a complaint from a family of the deceased. A participant would complain, and then a team would be put together to review the decision that was taken.
Yep, but now I think we must talk about a review that is being done at the instance of the NDPP without even any complaint having been lodged.
1795.
But upon perusal, the NDPP, like it is the case in this particular case, that it was done at the instance of the NDPP.
Yes.
Let's just talk process. What is the process? What are they supposed to do, especially in relation to the prosecution team? Thank you.
Chairperson, what I would have done if the national director had asked me to do this, I would
No. I think the question is not what you would have done.
Oh.
Is what is the
what
process?
the process is.
Yes, thank you.
Well, I would have followed the process, but the process is a team is put together, and the team then will consider and evaluate what is the evidence that is available. Now,
Mr. Maema, I think we're going sideways again.
are we?
You've told us that the process is outlined in section 179, subsection 5 of the Constitution.
Yes.
What does that section say? You can find the provision and read it for us.
Section 1795D. The National Director may review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified by the National Director from the following persons: from an accused person, from a complainant, from any other person or party whom the National Director considers to be relevant. Now, in fulfilling the responsibilities in Section 17795D, the National Director would then put up a committee, a team.
But I mean, was this process here followed? I mean,
No, it wasn't followed.
this,
It wasn't followed. There is no representations within a period of time from an accused person, from a complainant, or from any other person that the National Director considers
Yes.
relevant.
Thank you, Advocate Maema. It will help if you were to just try to answer the asked questions.
It is difficult, Chairperson, when you when you sometimes have more information, and instead of
Your witness will tell you that one day.
thank you.
Thank you, Chairperson.
Thank you.
Thank you. I'm sorry, I'm going to take you a page back because I was slow in raising my question. Advocate Maema, you listed the 5 managers or the 5 people that you regard as the managers of the Katomena enterprise.
That is correct.
And you also indicated why you regard them as
Managers.
as the managers. But what I'd like to know is, where do we get this information, or did you deduce it from the dockets? What, for example, I'll give an example with Lochem. You say Lochem always made sure that whoever has to be on duty is on duty. Where and how did you get to this conclusion about Lochem and his participation? Thank you.
Chairperson, what we did is we look at the organogram of the Provincial Organized Crime Unit itself, and then we looked at the composition of the SVC unit, Serious Violent Crime Unit, and then we looked at the various incidents in which they participated, and we analyzed the roles that they engaged in from incident 1 until incident 23, and then we could see from the incidents that these are the particular roles that all of the managers were predominantly taking in the activities of the enterprise. So it's not only the organogram of the provincial organized crime itself, organogram, the activities themselves, and how the activities were executed. That gave us an indication of the roles that each of them undertook during the incidents.
The organogram does not make it clear that these people play this role. The organogram tells us that the Provincial Commander of Organized Crime, KZN, is Director Boysen.
That is correct.
That's all it tells us.
Yes.
But you took it further to say, well, with Boysen, already you've led evidence to show that he was managing, because he made sure that they have resources, and he would always be there and make sure that the reputation is intact
Protected.
and give instructions.
Yes.
But it is a bit. It is a bit not clear. Let's take Neville Eva. You say he's known for attention to detail, made sure that on every operation there will be relevant members, and but there will be people who can break down doors. But where do we find that information that Neville Eva played this active role in order for us to put him as part of the management of the enterprise.
Chairperson, in the when you look at how the activities unfolded at the incidents, at the various incidents where they did the raids, you will see that he is consistently the one that guards the scene that is being penetrated, and he's the one after somebody has been killed who makes sure that the scene will accord with the view that they were being attacked and it was a justified killing.
So this is taken, this conclusion comes from looking at each and every scene
That is
and
correct.
the participation of these members from the scenes.
That is correct, Chairperson.
Okay, thank you.
Perhaps one of the things we will do in due course is that there was a request for further particulars to the charges. You recall that?
Yes.
And one of the questions raised there was precisely why have you identified these 5 as managers?
That is correct, yes.
And you provided an extensive response,
Yes, Chairperson, we did.
which it's too bulky. We haven't included it in the bundle, but we will just make it available. Yes. Thank you. We were still at paragraph 351.2 of your statement.
That is correct, Chair.
And we have finished the part dealing with what is a manager and why did you conclude that the 5 you identified were managers. Can you deal with 351.2.2?
That is correct, Chair. Further, an accused can be charged with and can conceivably be convicted under both Section 21E and 21F. In Prince Law, the SCA rejected what it viewed as the absurdity of a manager of a multi-billion rand racketeering enterprise who has had minimal personal active participation would only be liable for the minimal participation role under Section 21E and not under Section 21F for the extensive managerial role played in a highly successful criminal enterprise. I note, however, that the SCA has cautioned that in that scenario care must be taken to avoid an impressive splitting of charges.
Yes, I just want to get the principle out of this passage. A person charged as a manager, can they also be charged as a participant?
If that person executed both roles, yes. You can charge him as both a manager and as a participant.
Because I suppose management is a funny concept because it also includes participation.
Most of the managers, they dirty their hands too, so they participate as well.
No, I'm saying even the way you've described management, where someone makes sure that a gun is planted.
Yes.
That is an offense.
That is correct.
Which is in Schedule 1.
Yes.
And therefore it would mean you are a participant.
You are also a participant.
Yes. Or even the organizing of making sure that the vehicle is available, but it's a vehicle to commit a murder.
That is correct.
So which would also be an offense of being a conspiracy to murder.
That is correct, Chair.
So that's the point I'm making. I'm trying to understand in 351.2.2 about being a manager and a participant is not...
it's not mutually exclusive.
Yes, you debated that earlier with the chair.
No, I didn't debate.
Well, you explained it.
I explained. I elucidated, Chairperson. I would not want to be in the position where I do that. I would be run over by a train.
Okay, that's fine. Thank you. All right, so that's the emphasis on that paragraph.
Yes, Chair.
And then 351.3.
The racketeering enterprise and the pattern of racketeering activity through which it conducts its affairs are distinct. A pattern of racketeering activity may be proven, but if that activity is not conducted by an enterprise, a charge of racketeering will fail. That said, the SCA has explained that proof of pattern may establish proof of the enterprise.
Yes, now just stop there because it's one of the areas in the Koch report if you look at their summary at paragraph 190,
is on page 69.
yes, 68,
She started at 68.
190.1. It's one of the reasons they say that you got the law wrong. It's because their view seems to be that an enterprise must always be separate from the racketeering activity. It says there is no evidence to establish the existence of an unlawful enterprise. Let's forget about the unlawful part. You've explained that
Yes,
they got the law wrong here.
Yes.
But if you remove unlawful, you just say enterprise separately from the existence of a pattern of racketeering activity. What is your response to that?
There is no evidence to establish the existence of an enterprise separately from the existence. There is ample evidence to show that, because I mean, if you agree that, if you hypothetically speaking agree with the prosecution team that the Ketomena, a serious violent crime, being a lawful institution, can constitute an enterprise. If you look at their activities, I mean, the enterprise exists and the activities can continue, but the members of the enterprise can be different from any given day, depending on who is available, depending on the resources that are available to the enterprise.
I understand, but I think the point here that they were making in 190.1 is that your conception of the enterprises collapses an enterprise with a pattern of racketeering activity, whereas the two must always be separated. I understand you're saying on the facts that's not what you did.
Yes.
You separated the enterprise from the racketeering activity.
Yes.
So they got that wrong.
Yes.
But there is the question of law. According to what you say in 351.3, is it always necessary that the enterprise must be separate from the racketeering activity?
No, it is not necessarily always so that the enterprise will be separate from the pattern of racketeering activity.
Because I mean the SCA says proof of the pattern may establish proof of the enterprise.
Exactly, yes.
In other words, you can look at the pattern in order to see that there is an enterprise.
That is correct, yes.
Can remind me, didn't Advocate Batoyi actually say that they are interlinked?
I can't say for
did
sure.
I miss that point?
I can't say for sure.
I'll look at my notes.
Yes, we will have to look at that, yes. I mean, it's odd because it would always be strange that in order for people to be convicted of poker, you must, in every case, try and find that the enterprise pre-existed the pattern, you know.
Well, Chairperson, in the cases that I had dealt with, particularly the one that I dealt with Judge Hendricks, J.P. Hendricks, as he now is, we debated this extensively because I had an individual as an enterprise. So to have an individual as an enterprise, his view was that then that individual must be present at all the scenes, or must have had a role in one way or another. But that individual was conducting his affairs in such a way that, you know, he engages different people at different minds to make sure that you know, all the activities that he wanted executed are dealt with, and to make sure that when he deals with individual C, sometimes individual D, who knows individual C is not aware that the manager is dealing with the other one. So the enterprise and the pattern of racketeering activity can coexist.
But don't they necessarily coexist? Because as a prosecutor, what you see is the commission of crime.
Yes.
What you don't see is whether behind the commission there's an enterprise.
Yes, but what you do is when you then consult with your witnesses and when you look at the complete picture, then you will see it. Because what you do is that we argued in reverse. We, having consulted with the witnesses, having heard what was prepared, and having looked at what happened at the scene, then you can be able to say, this is how it unfolded.
I understand that, but I'm saying this idea that this panel has that the two are to be segmented in every instance.
Not this panel.
Sorry, not the
Tikok
panel. The Advocate Tikok panel has this idea that the two must be split at all times. Strikes one also as being nonsensical, because what a prosecutor comes across is crime in the first instance.
Yes.
It's only when you try and unpick the elements of the crime that you see that there is an enterprise.
That is correct.
So the two will always be interlinked.
Yes. All the time.
Yeah.
Yes.
Then you deal with paragraph 352, where you set out who was charged with what. Maybe you can deal with that very briefly, because we've covered that quite extensively.
Chairperson, as noted in the indictment in the Ketomena prosecution, comprised racketeering charges and underlying predicate offences. In summary, of the 29 accused persons charged with racketeering under poker, 5 accused persons were charged as managers of the enterprise. The 5 I have referred to earlier.
Yes.
As the 5 were charged as managers in terms of 21F, and as participants in the racketeering enterprise in terms of 21E. 19 accused persons were charged as participants in the racketeering enterprise in terms of 21E of poker. 5 accused persons were charged under both Section 21F and 21E. Each one of the 30 accused were charged with a predicate offense. In total, the accused were indicted for 114 predicate offenses, comprising 19 counts of murder. We refer to those kinds of murders in the brackets. 8 counts of housebreaking with intent to commit murder, and those are referred to. 1 count of attempted murder, count 83. 3 counts of assault with intent to do grievous bodily harm, counts 4, 41, and 43. 1 count of malicious damage to property, count 45. 6 counts of theft, counts 24, 30, 50, 57, 93, and 108. 3 counts of pointing of a firearm, which are counts 26, 42, and 44. 23 counts of defeating or obstructing the courts of justice, which are counts 5, 12, 18, 23, 29, 34, 38, 51, 52, 56, 61, 66, 69, 79, 90 to 92, 97, 101, 103, 107, 112, and 116. 26 counts of unlawful possession of a firearm, which are counts 6, 10, 15, 16, 21, 27, 32, 36, 46, 48, 54, 55, 59, 63, 67, 73, 75, 77, 84, 86, 88, 95, 99, 105, 110, and 114. 22 counts of unlawful possession of ammunition, counts 7, 11, 17, 22, 28, 33, 37, 47, 49, 60, 64, 68, 74, 76, 78, 85, 87, 89, 100, 106, 111, and 115. In terms of the indictment, the accused included accused number 1, Boysen, the commander of Ketomena SVC, and Organized Crime, later the DPCI unit. We refer to them as the Ketomena unit. Accused 9, the section commander of the Ketomena unit. Accused 6, Neville Eva. Accused 15, Lochem. Accused 16, Van Donder, as group commanders of Ketomena. 353.4. The majority of the remainder of the accused were members of the SVC section based at Ketomena, whilst other accused were based at other units of the SAPS within the KZN, including Port Shepstone Organized Crime Unit. Chairperson, in the indictment, the predicate offences were grouped by incident type. Namely, we had taxi violence related killings. We had ordinary civilians or suspects, and then we had ATM bombing suspects.
Just explain that. What is that about? It's categorized like that in the indictment, but what was the significance of that?
Well, when we analyzed the incidents, what we did was we saw that some of them were taxi violence related. Means they come from Kwama Pumulo Taxi Association and Stenga's the Stenga Taxi Association. That feud. But we saw some of them ordinary civilians, people like Ba, who were just ordinary civilians who were considered by Ketomena as ordinary criminals. And then we had those suspects that were involved in ATM bombings. So those are the different categories of offences that we ultimately included in the indictment.
So it's people being killed because they are suspected of being in an ATM bombing.
That is correct, yes.
And someone else being killed because they are suspected of being, it's alleged that they are suspected because we know there is evidence showing that from Mr. Zungu that these people were not even suspects.
That were not even, yes. But then there would be ATM bombing related offences, taxi violence related offences, and just others that we saw just as ordinary criminals.
Yes, thank you.
Across the indictment, each indictment were made up of the following recurring elements: a lethal operation pleaded as murder or housebreaking with intent to murder, plus murder, occasionally attempted murder. 335.2, possession of offences charging the same accused person with unlawful possession of firearms and ammunition used in that incident. Post-incident misconduct, almost invariably pleaded as defeating or obstructing the course of justice by staging the scene, typically by planting a firearm on the deceased. Collateral offences where applicable included assault with intent to do grievous bodily harm on surviving suspects, theft of some of the items that they will see, the money or jewelry, malicious damage to property which would happen when the penetration team enters the house during the course of the raid.
Yes. Now, these features, there are 4 features of the offences you've identified.
Yes.
Being a lethal operation or a deadly operation.
Yes.
Possession offences, and then doctoring of a crime scene.
Yes.
And then the collateral. I mean, we have many wives of the deceased saying they were beaten up or assaulted during the incident.
That is correct, Chief.
Now, is this relevant at all to the point you made earlier that what we saw here is that it was the same offences being committed across time and space by the same group of people?
By the same group.
In the same method?
In the same method, continuously, with the knowledge that, we have cover, we have protection from general poison.
Yes. I mean, would this fit the frame, the 4 features that are identified, the frame of a pattern?
Yes, it would fit a pattern of racketeering activity perfectly. Yes.
And then 356 and 357, if you can deal with those paragraphs.
356. Each incident generated a cluster of counts, and it is the repetition of these clusters that the prosecution relied on to demonstrate a pattern of racketeering activity.
This is the point I was trying to get you to. Yes. That when you look at these activities and with the features, the 4 features that are there, that are present in all of the 23 instances,
Yes.
the most extraordinary thing. All of the 23 that you charge have those 4 features.
All of them have, yes.
Did you find out how this happened? I mean, I couldn't understand it myself, how in every scene there is a coordinated lethal attack.
Yes.
There is a weapon found.
Yes.
There is an assault committed on all of those people who witnessed it.
I don't follow your.
I'm saying, did you find out how it happened? Like, was it centrally planned?
It appeared.
How did it happen that it had exactly all of the 4 features across 23 separate instances?
You know, it had to have been planned to, to perfection, to come out in the manner that it came out. Because in all of the incidents, when I made the presentation to EXO, I said, if you go through 4 incidents, then you know what happened in respect of all of them. Because it happens in the same way. It happens in, all of them happens the same. And it ends up in the killing either of 1 or 2 or 3 of the suspects, or all of the suspects that they were dealing with. Yeah, so it's.
The other oddity is that in none of these 23 instances is anyone actually arrested.
None is arrested. Not a single of the police vehicles are damaged. Not a single of them are injured.
Yes. And Advocate Batoi then says this is not a pattern.
Oh, it is. If nothing fits the definition of, this is the perfect definition of a pattern of racketeering activity. I would have marveled the opportunity of presenting this case before a judge.
But you can still apply. I heard that there's a section, I don't know, section 35 or something, where the NPA can appoint a prosecutor from outside. Section 38. All right. And then anything you want to add on? You haven't dealt with 357.
357 is the enterprise alleged in the indictment was the formal SAPS unit, the Ketomena SVC organized crime, later DPCI unit, with the accused 1 Boysen as a commander, accused 9 Olifir, the section commander, and the group commanders as accused 9 Eva, accused 15 Lochem, and accused 16 Van Donder.
Yes, we've dealt with 358, which is I started with this when I asked you to explain why they were an enterprise.
Yes.
So unless there's something there that you feel you haven't said that is contained in your statement.
No, Chairperson, I think all that I've said is in the statement.
Yes. And we've dealt with the 359 because you've mentioned that it was not your case that the enterprise was unlawful per se. You accepted that it was a lawful enterprise, but it carried out criminal acts.
Yes.
And then we've also dealt with the next section about General Boysen as a manager.
Manager, yes.
We've dealt with the statement of Colonel Ayer. We don't need to repeat that. We've dealt with the statement of Commissioner Brown. We also don't need to repeat that. We've dealt extensively with the answering affidavit of General Boysen, so we don't need to repeat that either. What we haven't really covered are the draft statements of Mr. Danikas. We covered one statement, but only for one purpose, which was to establish that there is no need for a statement by a witness like Mr. Danikas to be signed.
there is no legal requirement for that evidence to be under oath, and because all that it requires is information,
Yes.
not a statement under oath.
Yes, but this time, what I would like you to do is just to set out for the panel your involvement in securing Mr. Danikas as a witness and leading up to the point when he signed the statement. And you will know why this question is relevant. It's because there was an allegation that you lied because you claimed that Mr. Danikas is a witness when you knew that he was not a witness. So this is your opportunity to set that out.
Chairperson, with dealing with Mr. Danikas, I made sure that I informed Mr. Matenjo that I will deal with Mr. Danikas myself, because having spoken to him twice, the third time I knew that when you deal with him, you ought to be careful. So, General Mabula was in Greece with him and informed me that he has a witness in Greece who has fears to come to the country, but who is prepared to give us a statement. And then, knowing the Mutual Legal Assistance Act and knowing that if a witness is outside the country and if I want to use his statement in a subsequent trial, I will have to obtain the witness statement in terms of Section 2 of the Mutual Legal Assistance Act. I advised General Mabula to obtain a draft statement. And he then came back to the country with that draft statement of Danikas, unsigned. Because what we wanted to do was to look at the statement and then see what is lacking in the statement, see what is unclear, and ask him to clarify some of the things which I dealt with myself. And then during the reign of Advocate Sean Abrams, I will deal with the inside part, because the outside part, the media, to me, were not as important as the inside part. Because Danikas, from the beginning, all the time, it had been our intention to call him as a witness. Yes, his name is not mentioned in the indictment as a witness. We didn't want to mention his name. The indictment specifically says in terms of Section 1443, which allows us not to include names to redact some of the addresses that will put witnesses' lives in danger. So Sean then said, Advocate.
So that's Advocate Abrams.
Advocate Abrams, Chairperson, my apologies. Then indicated the importance to consult with Mr. Danikas. And then.
So this is just in sequence. This is now after the judgment by Judge Govan,
After
who
the
set
judgment.
aside the racketeering activity, the racketeering certificate.
Yes.
And Mr. Abrams comes onto the scene.
Yes.
And what do you recommend to him as the prosecution team?
Then because of the concerns that were raised by Mr. Danikas, Mr. Abrams and I had a discussion with witness protection, Dawood Adams of witness protection, and the crucial aspect was to go and was for Mr. Adams to ensure the safety and security of Mr. Danikas, to hear from him what his concerns are and how we are going to be able to get his evidence before court. But then we then decided that perhaps we just witness protection and myself should just use one trip to go and see Mr. Danikas, which we did in that January of 2018. We then flew to Greece to go and meet Mr. Danikas. We met him for 2 days, and We discussed, he raised all the concerns, and he had a separate meeting with Witness Protection, Dawood Adams, and he had a separate meeting with me. And on the third day, we had a joint meeting, and we took down his draft statement, came down with the draft statement, with the videos and all the information that he gave us in a memory stick.
And did you yourselves watch the videos?
I watched most of the videos, yes. Yes. And then I came and I reported to senior management, and then that's when we commenced the process of obtaining his statement in terms of the Mutual Legal Assistance Act. Yes. I traveled to Durban. I met the chief magistrate there. I presented my application. My application was signed. It was compiled in a proper formal application with diplomatic notes, and then it was taken through diplomatic channels. Diplomatic channels are Department of Justice, goes to Foreign Affairs, and then Foreign Affairs then goes to the embassy. The embassy then channels the application to the embassy of Greece, and the document ends up in Greece. The relevant authorities in Greece then deal with the application, meet Mr. Danikas, they obtain his statement, and the statement is channeled through diplomatic channels back to the country. So I was surprised when I saw Mr.
So just before you go to the point of being surprised,
Yes.
I just want to make sure the statement you're talking about is whether or not it's the same statement at 1A906 at GSM 90. Madam Chair. Sorry, I think I've now missed the page number. It's 1A 906. Yes, thank you. There is the original Greek version at 1A923, and then at 1A906 is an English translation.
Perhaps the council, we can adjourn here.
Oh, yes.
And Advocate Maema will quickly look at GASM 90, and when we reconvene, you can proceed.
Thank you, Madam Chair.
We will adjourn for 30 minutes until 11:45. Remember, you are still under oath, Advocate Maema.
That is correct, Chairperson.
We will adjourn now. Good day, everyone. Good day, Advocate Maema.
Good day, Chairperson.
Good day, Dr. Chauke. You are still under oath, sir.
That is correct, Chairperson.
Proceed, Advocate Toby. We were at GSM 90.
Yes, at page 1A923. Do you have that page, Advocate Maema?
1A906 or 1A9?
No, 1A923.
I am there, Chairperson.
What is that document?
It is the Greek statement of Mr. Danikas.
Yes, yes. Is it in Julius Caesar, where somebody has a line that says, they're asking, I think Caesar had made a statement at a meeting. They say, what did he say? It was, no, I didn't know. It was all in Greek.
Oh, yes, it is. They say Julius Caesarus.
Yes. Do you feel like that at the moment?
No, I had that feeling when I received this statement. I said, what is this? Because I didn't, for all intents and purposes, we are all speaking English. So when I saw the statement coming in Greek, I was surprised.
Yes. Can you explain what were the circumstances in which you ended up with a Greek statement?
Yes, what happened was after consulting him and then, no, after remember we ended where the documents have gone through diplomatic channels.
Yes.
Yes, and then we then followed up with a consultation, and then I returned and we await his statement, his signed statement. So when it arrived, I was surprised to find this. I couldn't read it and.
All right. Well, it appears to be dated 24. I would presume that's October 2016. In the actual statement itself.
Yes. What we then did when I received it, I then went to the extradition desk in the office of the National Director and said, we will require to have it translated. So they then went through the process of having it translated. They sent it to the Department of Justice, who then go on tender, and somebody is appointed who then translates the statement.
Yes.
So the statement came in English, and Carl van der Merwe was always on my back saying, we require a statement of Mr. Danikas. We require a statement of Mr. Danikas. I said, we have received it, but I can send it to you. And I actually sent him the Greek statement whilst we were awaiting the English version. And then...
No, what I'm saying is the Greek statement seems to be dated the 24th of October 2016. If you look at right at the beginning,
yes, it's 24 October 2016. Yes.
Yes, no, that's what I'm asking.
Yes.
Even at the end of that statement, if you look at 1A939 at the bottom.
That is correct. It looks like the 24th of October 2016.
Yes. And in fact, at 1A940, the Roman figures, the 24/10/2016.
That is correct, Chairperson.
Yes. Now, so that doesn't seem to have happened in 2018, but in 2016.
Yes, earlier in 2016.
Yes. Is that when you obtained the statement originally before the translation?
Yes, that is correct.
Yes. All right. And then, so you had been to Athens yourself personally?
That is correct.
And you were with someone else?
I was with Daud Adams of Witness Protection because our primary concern was the security concerns that were raised by Mr. Danikas.
Just the two of you?
Yes, just the two of us. General Mabula had traveled on a separate, before us on a separate flight.
Yes, now I understand. But I'm saying in the meeting with Mr. Danikas, it was yourself and Mr. Danikas alone.
That is correct.
Yes.
We had a session where we are alone, and he had a session with Mr. Daud Adams of Witness Protection, and we also had a joint session where the three of us were all together.
Yes. So this is how that statement was procured. The Greek statement was procured by you personally.
The Greek version, his statement was obtained with my participation, yes.
Yes, I mean you interviewed him in order
Yes.
to understand the areas the NPA was interested in.
Yes.
All right. Then we can move then from the Greek version. We needed to just get the context right about what happened there, how that statement ended up being where it is and which year. So we can move then to the English version, which you wanted to take us to.
Yes, then the statement arrived through diplomatic channels, and I was informed that we do have a statement. I was eager to have a look at it. When I received it, ultimately it was this statement.
It was the Greek version.
Yes.
And then?
And then I went back to the extradition desk and said, we'll require to have it translated. Then it went through from the NPA to the Department of Justice, and the Department of Justice then went out on tender to procure a translator.
Yes. Is that the document at 1A906?
And then the document at 1A906 was then produced.
Yes. Now, even that one says, under the words witness sworn testimony report, in Athens today, Monday, October 24, 2016, at 15:14.
Remember, the translation was just a translation of.
No, I understand, but I'm asking you a different question. Even the English version says, in Athens today, Monday, October 24, 2016, at 15:14.
That is correct, yes.
Yes. Now, which shows that actually the statement was taken in 2016.
Yes, that is correct.
Now, did you follow the process were you involved in the process that was followed by the authorities to obtain the English version?
I requested that it be translated. It went to the extradition desk, and from the extradition desk, it went to the Department of Justice to have it translated. I was involved, yes.
Yes, because there's stamps and signatures here that appear, and it's called official translation.
Yes.
Yes. I mean, I don't know the procedure for this. If you obtain a statement in a foreign language, what procedure must be followed to make it into a local language? But presumably, the people that know how to do it followed the procedure. Or do you know?
Yes, what the procedure that I went through the rules was, well, it's a witness that you intend to use in a trial, so you have to get it translated. So internally, then it went to the extradition desk to Department of Justice, which is our home department, and they then had the task to have it translated. They then decided to go on tender. They picked they utilized their internal processes to pick the translator that they decided upon, who then did the translation. When it came back to me, and then I thought, well, maybe before I avail it, before I disclose it in terms of Rule 35, let me send it to Danikas to affirm the correctness of the statement. He knows English. So then I sent to him. I was surprised when he came back. He said there are mistakes in the translation, and he mentioned what the mistakes are. He sent me a message by WhatsApp, and then I took it back the same way that it came, to bring the mistakes to their attention.
Yes.
And then I was then contacted to inquire whether they should utilize the same translator or a different one. And I said, all I want is a translated version. So whether you give it to the same person or another person, I would prefer the same person. But if it's not available and there is another one, it's still fine. So when the English version ultimately came, I was removed from the team.
Yes, but it had now been corrected with all of the errors that had been picked by Mr. Danikas.
Chairperson, when it came, I simply had no interest to have a look at it. I didn't want to look at it.
Yes, no, but I'm saying the second version that came had the corrections that Mr. Danikas had picked up.
That Mr. Danikas had sought to be effected on the statement. Yes.
Now, since you were there, you would know the statement, you would know the contents that you had discussed with Mr. Danikas. Now, that's what I need to take you through, which is the statement at at page 1A908, where starting with paragraph 1.
That is correct, Chair.
Yes. Now, I would like you to start reading into the record what the statement contained. I mean, you've read it before today. I mean, it's not like you're seeing this for the first time.
No, I'm not seeing for the first time, but I read it probably 4 or 5 years ago.
Yes, all right. But when you look at it, does it accord with your memory of the statement you took at the time?
It does accord with the statement that was finished.
Yes.
To me.
Okay. Now, so perhaps just start with the first paragraph where he describes himself.
The first paragraph reads, I, Ari Danikas, 45 years of age, a former member of Technotronic Electronics in South Africa, would like to make the following statement regarding the criminal offence of members of the Ketomena Organized Crime Unit, which I witnessed as a volunteer policeman in the unit since 1999 up to 2008. I would like to stress my deepest concern that this statement, which describes the criminal acts that I've witnessed, could put my own life and life of my immediate family, including my wife's relative in South Africa, in danger. And I make this statement on the agreement that the South African authorities will do their part to ensure the safety and security of my immediate family and myself. Furthermore, I'm deeply concerned that the description of this act will make me a target of false accusation and will involve me in the crimes of the members of the Ketomena unit, of which I was a witness but not a member of them. It should be stressed that any misconduct in order to compromise my credibility and the blaring of my character will be compounded by the very people who committed the crimes I've witnessed, and who are also officers of the police and who possess the means to counter the evidence against me. Therefore, I make this statement on the agreement that it will be protected legally and be ensured against these attempts to falsely...
Not that it will be protected, but I will be protected.
Chairperson, can I read again? I therefore make this statement on the agreement that I will be protected legally.
Yes, you said it will be protected.
Oh, my apologies. I make this statement on the agreement that I will be protected legally and be ensured against this attempt to falsely involve me in any crime. I also accept to be examined as a witness, but not in South Africa, only by video communication, and only after we have been offered witness protection.
Yes, does this accord with your discussion that you had with Mr. Danikas?
That is correct.
Yes. And did you think that his concern about his personal safety was justified?
I held that view, Chairperson, that his concerns were justified.
Yes. So you can... Okay, maybe you should also read paragraph 2.
Paragraph 2 reads, in the 1990s, I helped the police to arrest a number of shop robbers, and I was asked by Major General Boysen to be a reservist. after a meeting that had followed between us, I was asked by Major General Boysen to be a reservist after a meeting that followed between us. He then told me that he would take me to his own unit under his protection and that I would never have to wear a uniform or serve in a police station, and that he would use me only in his own very of high standard unit. As I was considered in my community a specialist in electronics due to my work and expertise in the field. All applications were, paragraph 3, all applications were completed by the unit secretary. All approvals and certificate of criminal records, as well as my applications, were completed by Major General Boysen himself. Major General Boysen
Just continue reading, otherwise my attempt at skipping some paragraphs is not going to work. Carry on. Please carry on.
Chairperson, I'm in your hands.
No, I thought we could skip, but I think the paragraphs actually interconnect.
They do.
Yes.
They do. Major General Boysen personally transported me in his car to the various government departments in order to submit the relevant applications. He also had a serious disagreement with the commander of the police department, where I had been booked as a reservist, because from the first day of my registration, Major General Boysen ordered my transfer to the Ketomena unit. Paragraph 6. I have submitted all my detailed records of the case files from 2000 to 2008 to an electronic file I handed to Lieutenant General Mabula. These are the same records that I filed twice a month at Major General Boysen's office at the provincial headquarters. The same records were also collected personally once a month in person by Police Officer B. Michel, who was working at the central office of the reservists under command of the Police Chief Officer Kennedy. Paragraph
Just hold there. You know, that timeline is crucial. That the evidence he was covering is between 2000 and 2008, because it's always been accepted in this case that Mr. Danikas is testifying on matters that predate the period covered in the indictment. But when you see the 2008, isn't that a period covered within the indictment?
That is a period that is squarely within the indictment, yes.
All right, thank you. Carry on.
Paragraph 6. I have never been paid for any term of office as a police
For my
reservist.
term.
I've never been paid for my term of office as a police reservist. In addition, I have been injured on duty many times and received medical care at the expense of the state. As a result, I have permanent injuries to my back, knee and neck. Paragraph 7. I've been given police firearms such as a 9mm Beretta Parabellum, which was given to me permanently with a special permission from Boysen's office. And I was also given a pepper spray, handcuffs, a police siren, a safety vest, a police light for my private car, a police radio transmitter, and a common crime scene investigation kit, like the one that all members of the unit had in their vehicles. I have in my possession letters signed by Boysen himself, which authorize all the above concessions. When I was called to join operations in my field of expertise, I was also assigned a R5 rifle for the duration of the mission. Paragraph 8. I've been trained in firearms handling, special units method, and in crime investigation procedures. The members of the Ketomena unit usually wore regular clothes. Paragraph 9. At the time, I was a very close friend of Major General Boysen's family. I sold him electronics from my store at a discounted price. I gave for free electronics from my store to him and his family, and I did a lot of repairs without any charge and spent a significant amount on other gifts and entertainment for him and his family. Major General Boysen generally had the requirement of me to entertain him and his family at my own expense in return for my protection from criminals, to give him my apartment to use during his private moments with his mistresses. He would call it a favor for a favor. He had similar arrangements with other businessmen I knew. He always demanded some type of a favor from this businessman, and in turn arranged for his team from Ketomena unit to protect these businesses and to sort out any problems that the businessmen might had with the law or security. For example, during most instances that I was traveling to Greece, Boysen posted a Ketomena police officer to guard the premises of my business for as long as I was away. Some of the police officers who guarded my store were Shane Naidu and Pandey Viresh. When I had to send my wife to the bank with large sum of cash, Boysen would send armed members of the Ketomena unit to escort her to the First National Bank in Musgrave. When Interpol and FBI members arrived in Devon, Boysen ordered me to meet them for lunch and dinner at a Greek restaurant, and he expected me to cover all the costs so that he looked good. When Boysen wanted to buy a Mercedes-Benz from a local dealer in Devon, he asked me to call the owner of the company, a wealthy Muslim and a member of the family who owned the NMI dealership, and pass him the message that he wanted to buy a good car at a good price in exchange for help from members of the Ketomena unit in the event of theft or hijacking of the cars of the dealership. Paragraph 10. Major General Boysen was responsible for some of the incidents that occurred at the Ketomena organized crime unit. He was always called on high-profile incidents and any serious shooting incidents involving murder of suspects by his members. Paragraph 11. Other times, he would arrive at the shootout when many suspected criminals were killed. If the shooting episode was near driving by car, he would always drive there, and on many occasions he would call me to meet him there as well. He often asked me to make use of my siren in order to get to the crime scene faster. Following orders by Major General Boysen, in several occasions I also received photographs from the scene of the crime before the arrival of the official photographer of the forensic laboratory. These photographs are available for examination. Paragraph 12. I was useful to him, Major General Boysen, since I had shown to the unit that I was observant with detail and could use my own latest technology equipment exclusively for the unit in the crime scene. Paragraph 13. I sometimes escorted Major General Boysen just for companionship. Sometimes he was too drunk to drive, so I was driving him with a car to a certain crime scene. I have recorded a particular case where Major General Boysen was in my house when he was called to a triple murder crime scene, and followed him with my own car behind Major General Boysen's car, who led to the scene of the crime. At the time, he was drunk and caused an accident going through a red robot in Musgrave area. From there on, he proceeded to attack the driver of the other vehicle involved in the accident, and I was obliged to physically hold Major General Boysen from attacking the other man. Then I drove to the crime scene with him in my car. Previously, he had managed to drive his damaged car back to my house. The photograph of the damaged car parked outside my house is at our disposal. After the incident, an insurance investigator who was a former police official called me and questioned me regarding the car accident, but I had already received orders from Major General Boysen to lie to him and cover up the fact that Major General Boysen was drunk at the time of the accident. Paragraph 14. Major General Boysen was very proud and passionate about the work of Ketomena unit and the fact that they were shooting criminals, in inverted commas. His favorite phrase was, "I can people disappear." But I can make people disappear. Did I read it wrongly?
Skipped make.
Oh, my apologies. I can make people disappear. By the way, the African suspect who was wanted for his connection to the above triple murder was shot and killed by his members. And the second officer, Mosi Moster, proudly gave me digital photos while being in my business. These photos are stored on my computer and are at your disposal.
Yes.
Paragraph-
So what does this mean? Twice he has referred to pictures and photographs being at your disposal. What does that mean?
It means we can access them and we can utilize them in whatever investigation that we are busy with.
But does it mean he had shown them to you?
Yes, he had shown me quite a number of pictures. Most of them I loaded on a blue memory stick that I bought in Greece. I stammer, Chairperson, when I have to pronounce any word, any G that is followed by an R. So I take time when I'm going to say a word that has a G and an R, because I know I will struggle with it.
Yes. So what happened to that blue memory stick?
That memory stick, on my return, during the report that we gave to Advocate John Abrams, I connected it on my computer and I showed it to him, and it was part of the dockets. It was part of the Ketomena dockets. It was the dockets were later reduced to a disk. So in that plastic container that contains the 4 discs, the memory stick was also there.
Yes, and then he's also referred to video footage. Did he show you that?
He showed me the video footages. Some of them would have been the video footages that we already had. Some of them were those that we didn't have. Those relate into the dockets where we are of the view that the evidence was insufficient.
I see. And then what happened to those, the ones that he gave you? Did you...
Everything that he gave me, I loaded it onto that memory stick.
So it made its way to the docket in the end?
It made its way to the docket, ultimately. And it was part of my report back to the management of the NPA, to Advocate Abrams and the team.
No, the reason I ask you about this is that, there's been lots and lots of talk about ambush in this case, that Advocate Batoyi was ambushed with video evidence. But the video evidence has actually been in this docket since 2016.
That is correct, Chairperson. The video evidence was there. And most of the time when you present to the NPA, the veracity of the dead bodies and the blood there just makes people, and they feel like we've had enough, we've seen enough, it's enough.
Yes, no, I understand that, but the point is really this: if somebody doesn't read the dockets and then they complain later that they've been ambushed, whose problem is that?
That's your own ignorance by not reading sufficiently, that you cannot blame others for it.
All right. And who is Mosi Mostert that is referred to in this paragraph?
It's one of the it's one of the accused persons who's referred to in the indictment.
Is he the person referred to as Inspector Mostert?
Inspector Mostert.
This is the big, bulky...
The big, bulky, accused number 9.
Yes. Thank you. Carry on with paragraph 15.
Paragraph 15. In October 2001, I was having dinner with Major General Boysen at News Cafe in Musgrave Shopping Centre in Durban. Major General Boysen showed me a photograph of a suspect who had escaped, who he claimed to have faxed threatening material to senior justice officials who had previously in the past convicted him of various crimes. Major General Boysen identified the suspect as Jabulani and told me that if I saw the man in the photograph, I would have to plant a bullet in his head. I asked him why. He told me that an order had come from very high, from the judiciary circles, that he should not be captured alive, as he would escape from prison again. He said that the man was a member of a house burglary that was out of control and raped women during burglaries. After his arrest and escape, the members of his gang themselves began to turn against him and gave information to the police about his activities and his whereabouts. Paragraph 16. On October 18, 2001 at 12:30 p.m., Major General Boysen invited me to participate in a mission. This happened either the same afternoon when I and Major General Boysen were dining at News Cafe or 1 or 2 days later. I recall this date in my memory by consulting my records, as I will never forget what happened that day, since it was my first field operation where a death had taken place. I do not remember if I drove to some collection point with the rest of the police or if I was picked up from my house. Major General Boysen invited me to drive with him in his car to a small town. I think it was called Umlazi. We were followed by quite a few members of Ketumena unit in discrete vehicles. Major General Boysen remained in the car and I participated with the other members in conducting raids in homes to search for suspect Jabulani. Major General Boysen took me there as a member of the unit. That night I was armed with a gun as well as my own weapon. Paragraph 17. More than 10 years arrived.
10 members.
What did I say?
Just trust us.
I do, Chairperson. More than 10 members arrived at the suspect's home. I cannot remember who used what kind of weapon. What I remember is that Jeremy Martin had an automatic police rifle. I saw Jeremy Martin kicking the door. At that moment, I was near the entrance of the house and could see a woman and children lying on a bed. Martin dragged the suspect out of the house in the rain, wearing only a dark underwear, and we stood around him in a circle while Martin was trying to put on him his handcuffs. I remember that this person was Jabulani. He was lying down on his stomach. Suddenly, Martin ordered the suspect to stop moving after he got him handcuffed and moved towards him and grabbed him. The suspect and Jeremy then slipped along 2 or 3 meters downhill outside the circle. At that moment, another policeman, I think he was called Eddie van Rensburg, told me in abusive language to leave from there. Then I heard shots and the suspect was dead. I personally believe that up to the moment of his death, the suspect was not armed. Major General Boysen was the general commander of the operation. I remember that after the shots, I phoned Major General Boysen, who the last time I saw him was standing at a distance on the hill in his car next to the rest of the parked cars of the unit. Then in the morning, he came to the place where we were and congratulated the members of the unit. The members that were present at the point where the incident happened, as well as Jeremy Martin, they later claimed that the suspect had a weapon hidden somewhere nearby, a claim I seriously questioned, as the suspect was surrounded by more or less 10 police officers armed with rifles. The next day, I was having dinner with Major General Boysen, and I remember expressing my concern about this. But he replied that I just imagined the facts and that this was a clear case of resistance to arrest and that the suspect was trying to shoot police officers. Paragraph 18. I remember an incident where I used Major General Boysen's gun to shoot a suspect. The incident happened in my store in Devon in 2001. Paragraph 19. My act was fully justified because I stopped an armed robber who had attempted to kill a security guard and myself after he had robbed my shop and threatened with a gun. Me, a member of my staff, Major General Boysen, and his 16-year-old daughter. Major General Boysen pulled his gun out of his case, which he had on his ankle, but froze. So I grabbed the gun out of his hands and ran after the armed robber. Then I saw that the armed robber tried to shoot the guard named Charles with my own pistol, which he had removed earlier. He also turned against me. I shot 2 low shots and injured the robber. I shot low as I did not want to injure the passerby. The importance of referring to this incident is because Major General Boysen had altered the scene of the crime by ordering me to change my testimony to cover his cowardice, and the fact that he, a senior police officer, had allowed me to use his weapon at the scene of a crime. He also threatened the investigator, police officer Jack Miller, who did not want to change my original testimony. When I handed a copy of the armed robbery from my company's security recording system over to a newspaper journalist, and after the journalist published a negative commentary with the title "Top Police Officer, a Hero or a Coward," I was threatened by Major General Boysen, and the journalist who wrote the article was fired, and for fear change city. Paragraph 20. On February 26, 2004, I called Ketomena police officers to come to my Technotronic store on Smith Street to arrest the guy who came to get a stolen laptop. The suspect was taken to Ketomena police station. I accompanied them as I was a policeman who arrested him, and I wanted to take part in the investigation. It was also a way to accumulate more duty hours, as every search that I was conducting, it had to be done officially during duty hours. At the offices of Ketomena Serious Violent Crime Unit, they undressed the suspect, tied him to a chair, and went to the torture of drowning and hitting him. I remember that among the members that were present were R.C. Maharaj and Varesh Pandey. I recorded the incident secretly using one of the first generation smart camera phones. At that moment, the unit members did not know that the phone had a camera. I pretended to have made a call and recorded the torture because I realized this was wrong and I had to do something about it. This recording had been copied from my phone to my files. I handed it to Lieutenant General Mabula.
Sorry, just before you move on, did you yourself see a recording of a suspect being tied to a chair and tortured?
I did see that recording.
I put it here to this panel to Advocate Batoi, who claimed not to have been aware of it. And I subsequently heard in the media that Major General Boysen said the video could have been taken from Guantanamo Bay. So he was still making fun of it.
Chairperson, these are some of the videos that were handed to me that I loaded on the memory stick that was part of the dockets that were kept at the head office. So if anyone had cared to view that memory stick, you would have found all those recordings in the in the memory stick.
Yes. So you were Lieutenant General Mabula, and then carry on.
That is correct, Chair. When I later showed the recording to Major General Boysen, he just laughed and said to me, "That's how things are done to get results." He also wanted me not to show it to anyone, as I would find myself in trouble. He asked me for a copy and a color photo of a specific snapshot that showed Viresh Pandey, and told me that he wanted it in order to incriminate Pandey, with whom he had personal differences. As far as I know, he had never pursued any disciplinary action against the member of his team, but I believe he warned them of the responsibility that I would record the tortures. Of the possibility, not responsibility. I believe that he warned them of the possibility that I would record the tortures in the future, because since then they would avoid taking me with them in the interrogations. In 2008, I left South Africa due to the threats that I was getting for my life and the sudden pressure I received from Boysen when members of his unit appeared in my house to suspend me and take my gun away, placing in this way my life at risk, because after hundreds of arrests of suspects at my business premises, I had been targeted by various criminals. When I arrived in Greece at the end of 2008, I felt secure. I tried to get in touch with various government bodies and with various journalists to inform them of the tortures and mistreatment that was taking place, as though it was wrong. As I thought it was wrong. But no one seemed to be interested in publishing anything against Boysen, so I uploaded the experts from recordings on YouTube regarding case number 297 of 2004, archive torture in the office. On March 30, 2004, a drunken man harassed the chairperson. I'm now at paragraph 21. On March 32, 2004, a drunken man harassed the owner of a pie shop next to my own shop on Smith Street. Major General Boysen happened to be in my store, grabbed the suspect and dragged him into my store with my help. Archive workshop blood video 1. Major General Boysen took the suspect at the back of my store, where I saw him attacking the suspect with his fists and threw him down unconscious, leaving a lot of blood on the floor. Later on, members of the police arrived and under the orders of Major General Boysen took away the suspect. Immediately after, it must have been the next day, Major General Boysen either dictated to me or gave me an affidavit. I do not remember what it was of the two. In this affidavit, it was falsely reported that the suspect had attacked one of us and tried to murder one of us with a screwdriver in my store. I do not remember if the affidavit was referring to myself or to him. That never happened, but I was obliged to sign it as Major General Boysen ordered me to do so to justify the use of excessive and unnecessary force. It refers to 30 March 30/03/04 1545, 30/03/04 1900. Suspect arrested at the police station on at BKOAD Street, maybe Broad Street.
Broad, yes, I think you're right.
Paragraph 22. On 21 January 2006, Major General Boysen came to my shop and I told him a story about his officers. When I was in a car with Veli Olivier and Eugene van Tonder, senior members of the Ketomena unit. They were driving.
Just hold those two names, Vili Olivier and Eugene van Tonder. We've come across them before. Can you explain the context?
That is correct. Olivier is a section commander at Ketomena, and Eugene van Tonder is also a member of Ketomena. They are accused persons in the indictment.
Yes, thank you. Carry on.
They were drinking around Smith.
Driving, not drinking. Not yet.
My apologies, Chairperson.
Are you feeling exhausted? If you do, you can alert counsel, then you can stretch your legs.
Chairperson, I think it's my eyes and my spectacles are tired of looking at black and white for a long time. But I can continue.
That is exhaustion. But
yes.
I mean, you want to have a break or do you want to carry on?
I think, Chairperson, for the sake of continuity, let's continue. If I cannot manage, I will indicate. Chairperson, I have managed court sessions the entire day.
You may proceed, Adv Maema.
Thank you, Chairperson. On 21 January 2006, Major General Boysen came to my shop, and I told him a story about his officers. When I was in a car with Willie Olivier and Eugene van Tonder, senior members of the Ketomena unit. They were driving around Smith Street in one of the discrete government cars that had been assigned to Ketomena unit with tinted windows. It could have been a black Lumina or a silver BMW. Van Tonder lowered the window slightly and started shooting with an air gun against the passers-by, aiming in particular at black passers-by for gun, laughing as he fired at them.
For fun.
For fun, not for gun. My apologies. I remember throwing a guy down from a bike and injuring some others, including women. When I told this story to Major General Boysen, he described to me in detail how he and his colleagues often did this, and that he himself had participated in this. He laughed as he told me this story. He also told me that an injured citizen had opened a case and gave the vehicle registration number from which the shots were fired, in which vehicle I was also in, and that this number belonged to the Ketomena unit. Major General Boysen said the complaint had been sent to his office and had, open brackets, had been already sorted, close brackets. From this, I realized that he had covered it. See video 2. Paragraph 23. On 27 October 2006, at around 9 a.m., 4 suspects were arrested in Durban's airport arrival section by members of the Ketomena unit. Some of the members who were present during this arrest were Major General Boysen, Moster, Van Tonder, Vic Pandey, Peter George, Shane Naidu, Mukesh Pandey, Anton Lokum, Sergeant R. Lee. This arrest was also attended by Adele Sonikas, who was invited there by Major General Boysen.
And who is Adele Sonikas?
Adele Sonikas was a female member of the Ketomena unit who was known to be close, who was known to have very close personal relations with General Boysen.
Is a police officer stationed at Ketomena.
A police officer stationed at Ketomena, but who had close personal relations with General Boysen. This arrest was also attended to by Adele Sonikas, who was invited there by Major General Boysen. Those arrested were taken to the Ketomena police station and were interrogated one by one. During this interrogation, I was present. I was witnessing the interrogation and the subsequent torture of one of the suspects, which happened during my presence and the presence of Major General Boysen. After a short while, Major General Boysen said he should not be seen by anyone there and left. Major General Boysen later said to me that Mostert has shot and killed 2 suspects after the one of them attempted to hit him with a shovel. In addition, Major General Boysen said to me that he arrived at the scene immediately after the incident and that one of the suspects was still alive, waiting for the ambulance to come. General Boysen further said that he had bent in the ear of the suspect who was dying and whispered, "I told you I will kill you if you were trying to come back." Paragraph 4. In April 2007, Major General Boysen and Adv Danikas visited me in my house after he had received a phone call from one of the members of his unit who had reported a shooting incident in Malvern. Adv Danikas was the police officer of the Provincial Organized Crime Unit and the secretary. During the day of that incident, she and Major General Boysen visited my home. They had a love affair. We went to the crime scene where I saw several members of the Ketomena unit. I found 2 African men lying in the garage of a house. One was shot and killed in the car, and the other was injured and still alive, but was in great pain and bleeding heavily. Major General Boysen said to me that they would call the ambulance and the Independent Complaints Directorate only if the second suspect died. So everyone waited around the second suspect to succumb to his wounds. I was able to use a video camera to record the crime scene in the presence of Major General Boysen and the rest of the officers involved in the shootout. I was always allowed to record crime scenes for the unit, and later it became clear that this was how journalists were bribed by giving them my own photos as exclusive publications in exchange for favorable stories. But I came to the conclusion that they wanted the films for their own private collections as well. That day, when I realized that the robber would die, I focused my camera on him, so I would later have a recording on how the unit left a suspect to die. Later, 2009, I posted this video on YouTube. I was also instructed by Mostert and Olivier to collect from the floor a number of spent large caliber cartridge casings. After I put them in my pocket, I handed them to Mostert and Olivier as they requested me to do. File suspect Melvin dies.
So if we can just stop here, did you see this video?
Yes, I did see the video.
Because it's also the second video I played here under the title Suspect Melvin Dies, and put it to Advocate Batoyi, who also claimed ignorance about it.
I saw that the day when the video was played, and it's one of the videos that Ari Danikas showed me.
Yes. Carry on.
When I told Major General Boysen that this was wrong, he became aggressive towards me and told me that it was not Ketomena's duty to provide medical care to criminals. Paragraph 25. The suspect died after a few minutes. I requested Major General Boysen to call an ambulance 3 times before the suspect died. This can be heard in the video. Later, I was informed by Major General Boysen that the driver of the police car with which the robbers escaped was a police informant and had given information at Ketomena's office for the planned burglary, and that he had left after he had dropped off the suspect at the house that they intended to break in. The suspects then were shot and killed by the unit. Paragraph 26. When we left the scene of crime with Major General Boysen and returned to my house, I played the video in the presence of other acquaintances of mine, and he gave me the specific order of getting rid of the video. Otherwise, I would have a serious problem. I chose to keep it and uploaded it on video in 2009. On November 15, 2007, the robbers who were part of the gang that stole jewelry and watches shot a police officer at the Pavilion Shopping Center in Durban. I went to the scene along with the Major General Boysen. Other members of the unit that I remember being present there were Mostert, Olivier, Van Donder, Peter George, Rakesh Maharaj, Mukesh Pandey, and Shane Naidu. I was with Major General Boysen when the incident happened. We may have also gone together with the car. Sorry. I helped the forensic team to spot the scene of crime and to gather evidence. This is kept in my file, and I also have the photos of the scene of the crime. Paragraph 28. On November 23, 2007, a Greek citizen, Kostas Sourakis, was arrested at OR Tambo on a flight of Olympic Airways to Athens, who was in possession of many watches later identified as those stolen from the Pavilion Shopping Center 1 week earlier. The suspect was taken to the police station of Ketomena unit that night and was interrogated for about 2 hours. I was called by Major General Boysen to attend the scene in order to act as interpreter. Other members of the unit I remember to be present were Mostert, Eugene Van Donder, Mukesh Pandey, and the reservist Vic Pandey. Paragraph 29. I saw the suspect being stripped of his clothes and being tied up on a chair naked. Immediately afterwards, he was tortured and beaten by Ketomena members, who also put a bag over his head and pouring water over his head, tried to make him drown until he confessed about various crimes he was accused of. During the interrogation, of Sourakis, I slapped him when Major General Boysen asked him his name and tried to fool us, claiming that his name was Malakas, which is a Greek swear word and means a masturbator. This happened at the beginning of the interrogation while they were around a table with Major General Boysen. I have no involvement in the torture of the suspects. Paragraph 30. On May 24, 2008, I received a phone call from Mostert to help in a crime scene on 5th Avenue, Morningside, Durban, where a suspect was allegedly died while Mostert and members of the Ketomena unit were trying to capture him. When I arrived at the place, they showed me a corpse on the ground, and I was refused to enter into the scene of crime by Olivier. Later, Mostert told me that he had tried to shoot the suspect while the suspect tried to climb out of the window and fell out. Reference May 2008, 24 May, 100 to 100.
Yes. Now, this date, 24 May 2008, is this within or outside of the indictment?
It is within. It is an incident in one of the incidents in Malvern.
Yes. Now, this notion that has been peddled around that Mr. Danikas has no relevant evidence because he is testifying about incidents that predate the indictment, is that true or false?
That is false.
Carry on.
31. The method used, paragraph 31. The method used by members of the unit were to strip the suspect of his clothes and physically attack him until he confesses or gives information. They would tie him naked on a chair and interrogate him. A relevant video. They would put a piece of leather or a plastic or a wood over the head of the suspect, always sitting behind the suspect, causing in this way suffocation. The suspect could not really see who was attacking him. A standardized method was always used, that is, they shot to kill, had tortured, altered the scenes of crime. Major General Boysen was called by his members to the crime scene to confirm and manipulate the scene. I was present in some of the cases I mentioned earlier. When I was accompanying Major General Boysen to the crime scene and ordered Major General Boysen in front of me to his members to collect all the spent police rifle cartridges casings and hand them to the responsible officer investigating the case. This usually happens after Major General Boysen had arrived at the scene of the crime. I would also like to testify that I have discussed my concern regarding Major General Boysen with Commissioner Brown, the head at the time of the provincial, the head at the time of the provincial headquarters investigators, and his wife Tilly, who were close friends of mine. They warned me to be very careful with Boysen, as he was a very dangerous man and could harm me. I would further like to testify that I had many personal conversations with Leticia Boysen, ex-wife of Boysen, and a close friend of mine who had also warned me that Boysen was a very dangerous man and had destroyed the lives of many people and that he could hurt me seriously. The same message was given to me by Boysen's children. I understand and acknowledge the contents of this affidavit. I have no objections in taking the necessary oath. I consider the oath binding on my conscience. Signature of witness, there is a signature of Danikas at the bottom of the page. And there is also a certificate by the translator who certifies that the statement was received by me, and the witness read and understood the contents of the affidavit. The witness signed this affidavit in my presence in Athens on the 24th of October 2016. It's dated 24 October 2016, the time 14:30. Place, the Office of the Special Investigator of International Judicial Assistance, Building 9, Office 127, Court of First Instance in Athens, Street Code 11362. There is also a signature of the investigator, and the name and surname is also written, the business address, as well as the title of the investigators.
Now, the manner in which the statement has been obtained and made official, would this have been admissible in court?
Yes, it would be admissible, and it would have been obtained in compliance with the Section 2 of the Mutual Legal Assistance Act.
Now, Advocate Batoyi said that Mr. Danikas, if I recall correctly, had never actually signed a statement.
No, the statement has been signed. You can see it.
Yes. We can move from that statement. Thank you very much for that. And
Chairperson, can I just say something in respect of Danikas? And I know Chair says I must just answer the questions that you answer.
Yes, but you can't help yourself. Yeah. Carry on.
Before you elaborate, I'm not sure on what. You remember there was a statement to one of the files that were brought to us, and there was a statement there by Mr. Danikas which was not signed. Early days?
Yes.
That is correct.
At that time, we did not have the Greek version statement and the translated statement. If my recollection was correct, Advocate Batoyi was referring to that statement saying it was not admissible because it was not commissioned and was not signed.
Chairperson, the fact...
May I finish?
Oh, I'm sorry.
It will probably be in the very first version of the Advocate Batoyi's file, which is the very first file of her testimony, her affidavit, and annexures thereto. I think Mr. Danikas' statement is there. The unsigned and unsworn statement. As may Advocate Ngcukaitobi, we now know what POCA says.
Yes.
About that, it will just be a matter for argument later, if it is necessary. You may say what you may say what you wanted to say.
Chairperson, all that I wanted to indicate was the view that Danikas would not be used as a witness that I expressed to Mr. Julian Knight. It's a view that we are also trying to protect Mr. Danikas, to remove focus from him. If we say he's not going to be a witness, he covers areas that are prior to the indictment, and it removes focus from him. Those that would do anything to discourage him to be part of the evidence that would be presented by the prosecutors would then leave him out and say, well, we've managed to convince him to convince the prosecutors to consider him irrelevant. So we let that narrative go on in the media when we knew actually, the evidence that Mr. Danikas has provided to us is similar fact evidence which is admissible in POCA prosecutions.
Yes, you may proceed.
Yes, thank you, Madam Chair. Yes, what I wanted to just close the section on Mr. Danikas and what you wanted to do with his statement.
Yes.
Now that you've obtained it, and it's now been translated officially.
Yes.
Yes. And what value did you think he would be to the trial? You've already alluded to the fact that it would be similar fact evidence.
That is correct, Chairperson.
But would it only be similar fact evidence given that he also has direct knowledge of one of the incidents?
Its most value would be on similar evidence, but there are incidents where he was present that are included in the indictment where it would amount to direct evidence.
Yes. Thank you. Now, we were analyzing, which is when we ended up with Mr. Danikas, we were analyzing the provisions of the Act, and we had looked at the elements of racketeering, the elements of patent, the elements of participation. You remember that?
I remember that, Chairperson.
Now, we need to close that off by looking at admissibility of evidence.
Yes.
Yes, which is all covered in the POCA legislation. The first is, what does the legislation say about hearsay evidence?
Well, hearsay evidence is admissible in POCA prosecutions.
Now, what does that mean? What is the significance of POCA specifically saying hearsay evidence is admissible?
Remember, if you want to go to the, hearsay is admissible. The significance is you can lead hearsay without an objection being raised or without an objection being sustained in POCA prosecutions.
And does it shift the onus? Because, under the Law of Evidence Amendment Act of 1988, if you want to lead hearsay evidence, you lead it as an exception.
That is correct.
But under POCA, it's actually not the exception.
Under POCA is a general principle that it is admissible.
Yes. Yes. And if you want to exclude it, you apply for its exclusion.
Exactly.
Yes.
Yes.
Now, what does POCA say about similar fact evidence?
Similar fact is also admissible in POCA prosecutions.
Yes. And if you want to exclude it, what happens?
Well, you'll have to raise one of the objections that is sustainable in criminal law. But as a principle, similar fact evidence is admissible.
Yes.
So even if that incident is different from the incident that you are dealing with, you can admit that incident if it elucidates one of the incidents that are referred to in the indictment?
There is, in fact, a judgment of the Constitutional Court on these issues, which I must say, Mr. Maema, we found it odd that the Court panel didn't even make reference to it.
Oh, yes.
It's a judgment of Savoy and others versus NDPP. We will give you now a copy. Reported in 2014, Volume 5, SA 317, where the poker was subjected to a constitutional challenge. And it dealt with all of these things about what a pattern is. But specifically, it had a section on hearsay. It was suggested that it's unfair to the accused in breach of Section 35 that hearsay is the default position. And the Constitutional Court addressed that. If you have the judgment in front of you, I would like you to go to paragraph 38.
Oh, it moved now to the act as it was handed over. Paragraph 38.
Yes. So from paragraph 38, but the specific paragraphs, after they've done all of the analysis, starts at 46 to 49. If you could read those into the record, 46 to 49.
Chairperson, should I indicate the
In our files.
judgment consent?
Oh, sorry, I'm told this judgment is in file C. Sorry, file. It's file 3 or file C? File 3.
Of your cross-examination.
Of our
bundle.
cross-examination bundle.
This one.
No, sorry, apparently C, but I'm not sure if I know what C is. Sorry, Madam Chair, I think I've mislaid you. It's, what is C?
Was it file 3?
I'm also waiting for direction, Madam Baloimer.
Does the witness have the judgment?
Yes.
I have the judgment.
he does.
I think you can proceed to look at that judgment.
Thank you very much. So if you could read from paragraph 46 to 49. The conclusions of the Constitutional Court on this topic.
I'm still at paragraph 15.
No, 46 to 49.
I'm just scrolling down.
Oh, sorry.
Chairperson, I am at paragraph 46.
Yes, just read those paragraphs to 49. There are 4 paragraphs.
Adverting to the applicant's complaint, it cannot be correct to say without more that all hearsay not admissible under the exception is of necessity unreliable and that its admission would result in unfairness. This is not to say hearsay evidence is without dangers. Quite the contrary. Just as some hearsay evidence not falling within the recognized exception may not be objectionable, some may be. Admitting objectionable hearsay in criminal proceedings may well result in unfairness to an accused, resulting in a violation of Section 35(3) fair trial right. It must be as a result of this reality that a filter in the form of the proviso has been appended to Section 2, subsection 2 of POCA. Paragraph 47. This section serves a twin purpose. First, it effectively does away with the hearsay rule on charges under Section 2(1) of POCA, and indeed other exclusionary rules. In this respect, this section differs from Section 3(1) of the Law of Evidence Amendment Act, which retains the exclusionary rule but permits the admission of hearsay evidence only under circumstances set out in paragraphs A to C of the section.
Yes, if you can just stop there, because this is the point you were discussing earlier.
Yes.
That the Constitutional Court expressly says, under POCA, hearsay is not the exception.
Yes,
And that's why POCA is different from the Law of Evidence Amendment Act,
that is correct, Chair.
where hearsay is the exception.
Yes.
Now, this is one of the things I struggle to understand with the approach taken by Advocate Batoyi and
Yes.
the DCOG panel that criticizes the reliance on hearsay, when the law is that hearsay, in fact, as a rule, is admissible.
That is correct. I also didn't understand it, and if they had engaged me, I would have informed them what my views are.
Okay, then it continues, paragraph 48.
Paragraph 48, section 2(2) insists that hearsay should not be admitted if doing so would render the trial unfair. In the light of the copious discussions above, I see nothing unconstitutional with this. Any unconstitutionality that there might be would be a function of improper admission of hearsay by the court consent. That is, a failure to use the filter in a constitutionally compliant manner. As mentioned earlier, the applicants have not placed before the court a specific set of facts, but have brought an abstract challenge. Therefore, the question whether Section 2(2) proviso has been applied constitutionally does not arise.
And paragraph 49.
Paragraph 49. Needless to say, it would be ill-advised to attempt to anticipate instances where admission of hearsay would be so unfair as to infringe on the accused's fair trial right. That is something best left to a trial court.
Now,
The
if you
issues
just stop here again. Now, if an accused say this admission is unfair, who must make that decision according to the judgment?
Well, the court will make the decision.
Which court?
The trial court.
Yes.
Yes.
Carry on.
Not the court dealing with the preliminaries.
Yes.
The issues, like to mention but a few, the nature of the evidence, its reliability or lack of it, its probative value and prejudice to the accused would have to be considered.
Yes, I mean, could the Constitutional Court be clearer? If there is a problem, the trial court will decide the problem.
Yes.
Yes. Thank you. I see, Madam Chair, that when I look at the judges who decided the case, there is also one Nkabinde J.
I'm just looking at you. If you look at the top of that judgment, you'll probably find the High Court reference case number. If it is reflected there, if it is not, it will be in the original judgment handed down. Does it show there?
It says, yes, it says KwaZulu-Natal High Court, Pietermaritzburg, Madondo J.
Yes.
Yes.
What year was that? In the High Court KZN?
not here in KZN. Yes, yes, that's correct.
You can check on the citation on top. If it doesn't show, we'll get that. The reason why I am raising this Advocate Chauke is to assess the year in which this constitutional challenge was raised. Remember, the matter was had in the Constitutional Court that year, and the decision was made. If it originated, say, for argument's sake, in 2009 or 2008, I think we must make an assessment of that. Who was the DPP in KZN that time? We can check.
Yes, we can check.
Your junior knows what I'm talking about. You can check.
Yes, yes, indeed. Thank you. Thank you. So that concludes the section on Mr. Danikas.
Yes.
The implication of, at some point, an unsigned statement, but at a later stage, a totally signed and commissioned statement.
And translated, yes.
And translated statement.
Yes, Chairperson.
You then come back and you hand that over to, is it Mr. Advocate Abrahams?
That is correct.
And then what happens? Did you then get? You said at some point you lost interest in the matter.
No, Chairperson, I didn't lose interest. My disengagement with the matter is when I was removed from head office.
Yes. Now,
when Advocate Batoi was appointed.
Yes, thank you. Now, the next section from your statement is an engagement with the DICOC panel report from paragraph 445.
Just before you go there, Council, at that stage, before you left, Advocate Sean Abrahams had also signed a racketeering authorization certificate.
That is correct, Chairperson.
Yes.
What was the role of Advocate Ngasana in relation to this racketeering certificates?
We did a presentation to Mr. Ngasana. He's an attorney, Chairperson, not an advocate. He's an attorney, Mr. Ngasana.
Was he not an advocate then?
No.
Or he was an attorney?
Yes.
In the DPP's office?
He was the National Director of Prosecutions, but he's an admitted attorney, not an admitted advocate. Yes.
Yeah.
So we did a presentation to Mr. Ngasana, after which he asked us to procure more evidence. But Mr. Ngasana never got to sign the racketeering authorizations. We did a presentation and he gave us the issues that he was not satisfied with. We dealt with them and we presented the request to him the second time. And I think our last engagement with Mr. Ngasana was when Mr. Chauke was told not to be be involved in this matter at all. The 7th of April in 7th of April 2015. Yes. But Mr. Ngasana never got to sign the racketeering authorizations. he kept on saying he needs more information. Until Mr. Abrams was appointed, we also made a presentation to him. I think we made 2 presentations to Mr. Abrams, to Advocate Abrams. I remember on a specific day, he asked for the dockets to read them over a weekend. Yes, and on the Tuesday he returned the dockets. And I think a week or 2 thereafter he signed the racketeering authorizations. In respect of all the accused persons that we have asked for racketeering authorizations for, including Major General Boyce.
Are you aware of what the attitude of Advocate Mlojo was in relation to the issuance of this racketeering certificate? Because at one stage she was a DPP KZN.
That is correct, Chairperson. My understanding of Advocate Simpiwe Mlojo's role was at the beginning before we even went to KZN, when consideration was given to appointing prosecutors outside KZN. His view was that himself, as well as members of his staff, had worked with the Ketomena police for a considerable time, and he felt that it would be better to bring outside prosecutors to bear on the matters to ensure independence and impartiality. So he was supportive of the idea that prosecutors from outside should come and assess the evidence in the dockets.
Would you be aware of his attitudes towards the involvement of Advocate Chauke as a coordinator, or his role as he was authorized by Advocate Jiba?
He did not have any concern with it. He did not raise any concern with me or with Advocate Matenjwa, who met him on the first day that the prosecution team went to KZN.
Are you aware of his testimony before the Zondo Commission?
I saw his views for the first time at the Zondo Commission.
Seeking to suggest, among other things, that Advocate Chauke acted with ulterior motive?
That is correct. I was surprised and shocked, because I thought all the time from my engagement in these matters, I thought, we are one team and we are all at idem as to what should happen. And, I was of the view that even after we had assessed whatever that was the contents of the docket, he would be part of the senior management to whom we would be presenting, and he would be part of the debates to sharpen our preparation, our focus on the merits of the charges.
Toby, I'm not cross-examining the witness, but I just, in the event, I don't want this to slip my mind.
Yes.
Advocate Moipone Noko, the former DPP KZN,
Yes, Chair.
was similarly approached after the racketeering charges had been withdrawn, to provide a report by Advocate Batoi. Do you know that?
No, I didn't know that. I heard it in her testimony.
What do you make of the fact that a decision was taken to withdraw the racketeering charge? Similarly, in 2019?
In 2019, Chairperson, yes.
Subsequently, in 2020, as I recall from her testimony, she was asked to provide a report regarding those matters. Shouldn't this have happened the other way?
It should have happened the other way around, Chairperson, prior to the taking of a final decision to get inputs from the role players.
And have you seen Advocate Noko's report?
I have seen it. It was sent to all prosecutors.
Then, yes, there were two reports, one directed to Advocate Batoi, and then she wrote a comprehensive one directed also to all the prosecutors. You saw the one directed to the prosecutors.
I saw the one directed to all the prosecutors. The one that was directed to to Advocate Batoi, I haven't seen even today.
My reading of that report, together with her testimony here, seemed to suggest that there was indeed evidence warranting a prosecution
That is correct, Chairperson.
in the Katomena matters.
That is correct. Even in the presentations that the team had with her, there are issues that we raised, we dealt with them, but she was convinced that there was sufficient to justify a racketeering prosecution.
Now, from 2020, remember Advocate Batoi took office in 2019,
That is correct.
meaning that by 2020, when she received the response of Advocate Noko, she would probably have formed a view that there was some form of evidence. Because in that report, there were summaries of the dockets.
Yes.
She would probably have formed a view that there is something
That is correct, Chairperson.
warranting a prosecution, or let me call it, there is evidence.
There is evidence upon which a prima facie case may be made out by the prosecutors.
Yes. And following that report, and advise me if I'm wrong, it seems nothing happened until today.
Yes, nothing has happened, Chair. You are very, very correct.
So you endorse the view held by Advocate Noko that the prosecution should have been proceeded with?
Chairperson is saying, I endorse the view that the prosecution should not have proceeded with.
Should have been proceeded with.
Should have been proceeded with, yes. Thank you, Chairperson.
Right. Advocate Maema. When Mr. Masana became the NDPP, this Katomena matter or matters were still pending at the desk of the NDPP.
That is correct.
And when he came into office, he did not dismiss the recommendations of the prosecution team, that is your team, out of hand.
That is correct, yes.
He actually engaged you,
Yes.
and sought for more information.
For more information, that is correct.
Now, you say at some point he then gave a directive that Advocate Chauke should no longer participate in the matter, and
That-
Advocate Noko should participate in the matter,
That is correct.
by virtue of her being now the appointed officer.
By virtue of Advocate Noko being the appointed DPP of KZN, and by virtue of the fact that the predecessor who fell, they have worked closely with the Ketomena team are no longer there now. She hasn't worked closely with the Ketomena team. She would be able to bear an impartial mind upon the facts.
Thank you. Now, after he had granted that directive, I'm talking about Mr. Masana,
Yes, Chairperson.
did he then continue to engage with the prosecution team? I've heard you said up to some time, and then there was, the case seems to have gone cool. But of importance to me now is whether even after he had then released Advocate Chauke of the position of coordination, did he continue to engage the team about the Katomena cases?
Chairperson, from the national director's point of view, the prosecution team would be engaged as and when there is a presentation made. But there was never follow-ups to check on us, how far you doing. It was left upon us. They felt, NPA management felt, as responsible prosecutors, we would on our own advance the investigations and ensure that the investigations are ready. But we knew that this being a high-profile matter, we would not proceed without having given a proper briefing to senior management.
Maybe let's talk about the presentation before Mr. Ngasana.
Yes, Chairperson.
After Advocate Chauke had been relieved of the coordination
Role, yes.
do you remember as to whether your team made further presentations or not before Mr. Ngasana?
To Mr. Ngasana, we made one presentation and not any other.
This presentation that you made before Mr. Ngasana, was it made when Advocate Chauke was still the coordinator of the team, or what is the position?
It was made when Advocate Chauke was still the coordinator, and it was at that presentation that Mr. Ngasana then directed that Advocate Chauke should not be involved anymore.
Just one question. Now you have advised us that you went to interview Mr. Danikas
In Athens, in Greece.
That's right. Now the question is, who was the NDPP at the time when you went to Greece to go and interview Mr. Danikas?
Advocate Sean Abrams was the national director at the time.
And that was post the era of Mr. Ngasana.
That is correct.
Thank you. Thanks.
Advocate Ngcukaitobi, it's almost lunchtime. Yesterday you referred to, just before we adjourn, maybe you can help me there. You made mention of the correspondence that came from the Hlapani attorneys.
Yes.
In relation to the matter of Mr. Mkhize.
Yes.
And you mentioned that there were about 5 letters or something to that effect.
Yes.
You need not check now.
Oh, okay.
You need not check now. And I was just trying to check precisely where on my notes, but I made a note so that you can refer us to the correspondence.
Yes.
Those letters, I know it's from Mr. Shosi.
Shozi.
Mr. Shosi. Yes. If you can just maybe highlight those areas for me. The letters, I know some of the letters, but you mentioned about 4 or 5.
Yes.
Yes, if your juniors can just maybe check the relevant passages, and then you can let me know when you reconvene.
Thank you, Madam Chair.
I think it is Adv Maema. We're going to take a lunch break until. We will take a 45 minutes break.
Madam Chair, I wonder if we can, we have a witness that we had agreed to see at 1.
Yes.
It's actually Mr. Mangena. He's been hanging around since 1 o'clock, and we would appreciate if we could just have an hour with him. That's unfortunately the only time we could squeeze out.
Yes. Let's do it this way. Let's have a lunch break for an hour.
Yes.
And if after the expiry of an hour, you still need more time to talk to Mr. Captain Mangena, send a message through our researchers.
Thank you, Madam Chair.
Yes. Advocate Maema, you are still under oath. We will adjourn for an hour thereafter until further notice.
That is
Thank
correct.
you. We adjourn. Good afternoon. Good afternoon, Advocate Maema.
Good afternoon, Chairperson.
Advocate Chauke. Advocate Ngcukaitobi.
Thank you, Madam Chair. And
You are still under oath, Advocate Maema.
That is correct, Chairperson.
yes, and apologies for the delay. As you can see, we're coming back as a team of 2 from a team of 4. So the other colleagues have been left behind to work through the statement. Mr. Maema, we were at Part D, paragraph 4.5 of your witness statement.
That is correct, Chairperson.
Yes, now you firstly address at 4.45 the report of Advocate de Kock. And you mentioned there at 4.45 the issue of the signature to the report. Can you just tell us what the concern is?
The issue of the absence of reports, actually.
Yes.
The absence of signatures on the report. Chairperson, 445, the so-called DCOG report purported to provide the then NDPP Advocate Batoyi with an analysis of the legal requirements for sustaining racketeering charges under POCA and an assessment of whether those principles, a racketeering authorization, should have been issued in the Ketomena matter. The report was purportedly compiled by advocates Rodney de Kock, Adv Tenga, S. Riley, and E. Mamabolo. Although it was only signed by de Kock and Mamabolo, there was never any explanation as to why Advocate Tenga or Advocate Riley did not sign the report.
Could I just ask you, I mean, in terms of this report, we don't know under any law that it is, I mean, do you know under which law a report like this was procured?
No, I do not know.
Yes, I mean, the report itself doesn't say what powers were being exercised when it was
Compiled.
Yes.
It does not say.
Yes. And hence the issue of its validity then, if it's got 4 members and it's signed by 2, they don't constitute the majority.
They do not, and there is no explanation as to why Advocate Tenga and Advocate Riley did not sign.
Yes. And you say, well, the report doesn't explain, but I understood that when the decision was taken by Advocate Batoyi to withdraw the charges, she called up a couple of people that were involved in the case and announced her decision, although she didn't circulate the report. Were you among those people?
Yes, I was amongst the people who were called, yes.
Yes. What happened in that conversation? Firstly, how did you know that you were to be called?
I received a call from the PA to Advocate Batoyi who asked me to come, received it on a Friday afternoon to come to a meeting on a Monday at 11 o'clock. I obliged. I was there. Most of the members of the prosecution team were also present. Advocate Mwiponi Nogo did not attend, but I think there was a teleconference with her. We were told that the decision has been made to withdraw the racketeering charges, and that the balance of the charges would be referred to the DPP. Yes, it was just a report back session.
Yes.
No reasons were advanced. We were not, taken in confidence with the DCOG panel report. Yes.
And did you engage with the statement that was announced? Did anyone respond back, or what happened?
Chairperson, in the NPA, we have a spokesperson who speaks on behalf of the NPA. So we do not speak. We do not express our views. We do not express any how do you say? You do not express any dissension, if any. If you hold a dissenting view, you Chairperson, you just die with your complaint.
Yes. So in that meeting, no one said we disagree.
No, we invited to say what our views are. We were called, 2 minutes, we were told, this is what's going to happen, and we left.
I see. So the meeting lasted that short.
Very short.
Now, you deal with this report further extensively from paragraph 446. And you remember that we already dealt with section 179 earlier, but you've covered it at paragraph 446, 447.
That is correct, Chair.
And then in 448, can you just deal with that specifically? Because it was an issue that came earlier in your testimony.
Chairperson, if reconsideration was in terms of section 179(5) of the Constitution, the panel should, in addition to receiving representations from an accused person and the complainant, have invited the prosecution team to make a presentation and clarify the process which were followed leading to the issuing of the Racketeering certificates. Should have familiarized themselves with the prosecution strategy and the theory of the case, canvassed any identified shortcomings in the prosecution memo, the indictment, or the docket, if any, apprised themselves of all the processes and documents in the matter, including the process that have served before the criminal courts, including the contents of all relevant dockets, requests for further particulars, if any, the state response to the request for further particulars, if any, accused application in terms of section 342A of the Criminal Procedure Act 51 of 1977.
Yes, thank you. Then in 449 and 450, you cite two judgments. Could you deal with those judgments? The one is Zuma versus the Democratic Alliance in 2014, ZASCA 101, delivered on the 28th of August 2014.
That is correct, Chairperson, where the court endorsed the tried principle below, and I quote, "The NPA as an organ of state has a duty to prosecute without fear, favor, or prejudice by upholding the rule of law and the principle of legality. It is also a constitutional body with a public interest duty. It behoves its officials to operate with transparency and accountability. It is a duty to explain to the citizenry why and how it arrives at decisions to quash the criminal charges against the accused persons, particularly where the matter involves a very senior state official. In pursuance of its constitutional obligations, it is incumbent upon the NPA to pass the rationality test and inform the public why it quashed the charges. In my view, the converse would make the public lose confidence in the office of the National Director of Public Prosecutions."
Yes. Yes, well, I mean, according to Advocate Batoi, the public statements that was issued, which she took us through, only told us that the DCOG panel had decided that there was no case, without explaining why it decided that there was no case for racketeering.
I follow,
Yes. How would that engender any public confidence in the NPA?
Not at all. To the contrary, it will. Why are we having prosecutors that are scared to prosecute when there is evidence eliciting the commission of offences? To the contrary, it will dampen the communities dampen their belief in the criminal justice system.
Yes, and then in paragraph 450, you deal with a different dimension of rationality. Can you deal with that?
That is correct. Chairperson, in 451, it's
450.
In 450, later in Zuma versus the Democratic Alliance and others, 2018, Volume 1, SA 200, decision of the SCA. The SCA also stated that the exclusion of the prosecution team from the process leading up to the decision to prosecute, especially the final deliberations that took place on 1 April 2019, was in itself irrational. The compelling conclusion is that this exclusion was deliberate. There were senior litigators steeped in the case, acquainted with the legal issues, and had a critical important contribution to make regarding the ultimate decision to terminate the prosecution.
Now, was the prosecution team excluded in the determination of the withdrawal of the charges against the Cato Mano team?
That is correct, Chairperson. We were excluded. We were never consulted. Our views were not sought.
Were you senior litigators steeped in the case?
I would submit Chairperson, that we were senior officials, senior litigators steeped in the case, having been involved with it from the beginning.
Were you acquainted with the legal issues?
That is correct, Chairperson.
Yes. Did you have a critical, important contribution to make?
Precisely, Chairperson. We had a very critical contribution to make in the ultimate decision whether to terminate or to prosecute.
And your exclusion in those circumstances, would it pass constitutional muster?
It will never pass constitutional muster. It falls far short.
Now, paragraph 452, you then deal with this that we've just covered now, correct?
That is correct, Chairperson.
Yes. And then the report is cited its conclusion.
The report ultimately concluded that the racketeering authorizations issued by Advocate Jiba and Advocate Abrams were invalid because a proper case for racketeering was not made out on the papers presented.
And then in 454, you connect the racketeering with the predicate offenses. What do you say there?
Although the NDPP said the DCOG report was consent with the reconsideration of the racketeering authorizations, it nevertheless prompted a withdrawal of the predicate offenses underpinning the racketeering charges. The prosecution team was not consulted on the withdrawal of the predicate offenses.
Yes. And then at 455 and 456, you...
Sorry. The withdrawal of the predicate offences was by the DPP KZN.
That is correct.
Advocate Harrison.
That is correct, Chairperson.
When was that precisely?
That was when I was removed from the matter. So when the predicate offences were withdrawn, I was already back in the Northwest.
But it could not have been in 2019 because that's the year when Advocate Batoi referred the predicate offences to the DPP for reconsideration?
I do not even know. I just heard in the media that Advocate Harrison had withdrawn the charges, Chairperson. I was not party to the office of the NDPP.
Thanks. Do you have an idea, Advocate Ngcukaitobi?
Yes. The colleague points me to SB 4229. 229. Yes.
We will make a note and get it later.
Thank you, Madam Chair. So at 455 and 456, you lay a foundation for your response to the panel, which I presume is something you would have said had you been consulted.
Indeed, Chairperson. The DCOG report's findings were based on a misapprehension of the legal requirements for a conviction of racketeering in terms of Section 21D of of poker, a woefully incomplete analysis of the evidence contained in the relevant dockets, and a misapplication of the law to the facts.
Yes.
In what follows, I summarize the evidence in the dockets that the DCOG report should have analyzed and how the evidence established racketeering charges against the accused.
Yes, sorry, before you proceed, I mean, in the evidence, and again, if necessary, if the evidence leaders take an issue, we can go through each docket. In the evidence of Advocate Nogo, we took her through 12 dockets that are just not considered at all in the DCOG panel. Just not, they're mentioned in one page, not a single statement about the contents of those dockets. Would that be consistent with your knowledge?
No, that is not consistent with how a proper review should be done. If you want to go to the merits of what you are dealing with.
Yes. Now, thank you. As I say, if necessary, I can give the names again of the dockets that are mentioned, but apparently not even opened.
Madam Chair, for Advocate Ngcukaitobi's sake, we do not take issue with that. Already there is evidence, so there's no need.
You speak up, sir.
I'm saying for Advocate Ngcukaitobi's sake and comfort.
Speak to the mic and speak up, please.
Yes, I'm saying for Advocate Ngcukaitobi's comfort, we do not take issue with what he says that based on what Advocate Nuko had said, there were 12 dockets which were not mentioned in the DCOG report. They were just merely listed there and they were not summarized. So there's no need for him to take the witness today.
Yes, thank you.
Thank you.
Advocate Mchene. Thank you, Advocate Nkcukaitobi.
Thank you.
Advocate Halley is here. I don't know whether...
I'm not sure why this particular aspect. Thank you, Madam Chair.
I must just say a lot happened this morning when you were not here in relation to certain aspects of the dockets not being pursued in details if the parties are agreeable. I'm just giving you that precursor.
Thank you, Madam Chair. I did have a discussion with my learned friend for the Chauke team, Advocate Ngcukaitobi, and I indicated to him that I would have a further discussion with him by the end of today, after we adjourn, so that I can understand precisely what it is that we have been asked to agree to. Once I understand that, I'll consider it overnight and then place our position on record tomorrow.
Yes, I just invited your junior this morning because these matters were discussed in chambers, and I thought it appropriate that we should let you have a say because you represent the NPA.
I appreciate that, Madam Chair.
Not necessarily that we anticipate the pending interlocutory application by you.
I made no assumptions.
Yes, thank you, Council. Advocate Council, we have now found SB 4229. In paragraph 3, mention is made of a unanimous decision by Advocate Batoi. Do you see that? The second line, second sentence of paragraph 3 at 229. And my understanding was that the decision was not unanimous because it is not, the report is not signed by all those who are purported to have agreed to the conclusions in that report.
That is correct, Chair. In fact, it's 2 out of 2 that have not signed. 2 out of 4. Did I say 2 out of 2? 2 out of 4.
Now, this SB 4224 does not tell us when Advocate Zungu, Advocate Harrison made a decision, Council. It was a letter by Advocate Batoye dated 16 July 2019 asking her to make a decision with regard to the predicate offences. So I'm still interested to know when did she then respond to this request by Advocate Batoye. If you know, we will try to find that, and then if you get the answer, let us know.
Do you know, Mr. Maema?
Chairperson, I have no idea. At that stage, I was already removed, and I was just focusing on my work in the Northwest Division.
Yes. Thank you. I mean, that information has been asked for before, so hopefully at some point it will be furnished by the NPA. Then in paragraph 457, you explain why you believe that the Court panel misapplied the law, misconceived the law and then misapplied it.
That is so, Chairperson.
Paragraph 458.
458. First, the report incorrectly assumes that an enterprise for purposes of poker must be an unlawful enterprise. This view was expressly rejected by the SCA in S versus ASEN. And the quotation from S versus ASEN, open quotes, there is no requirement that the enterprise be legal or that it be illegal. It is a pattern of racketeering activity through which the accused must participate in the affairs of the enterprise that brings in the illegal element. And the concept of enterprise and pattern of racketeering activity are discrete. Proof of the pattern may establish proof of the enterprise, but this will not inevitably be the case.
Thank you. Carry on.
Paragraph 459. As a consequence, the report mistakenly treats the formal legitimacy of the SAPS unit and the police hierarchy as negating the existence of an enterprise for the purposes of poker.
Yes, you've dealt with that.
We have dealt with that earlier.
Misconception earlier. Then there's a second misconception. You deal with paragraph 460.
That is correct, Chairperson. The report wrongly requires proof of predicate offences that give rise to a specific threat of repetition indefinitely into the future.
Yes, what's wrong with that?
Under poker, Chairperson, there is no requirement of a threat of repetition of the predicate offences, or that the offences must be part of an ongoing entity's regular way of doing business. It would also be absurd to require that the enterprise be currently active at the time of prosecution and the existence of a threat of repetition. If that were so, it would be impossible to prosecute the past racketeering activities of an enterprise.
Yes, and that's where you make the mention of the, what did you call it, the sexy boys?
The fancy boys.
Fancy boys.
Yeah.
That have begun and ended, and then,
yes,
then the NPA comes in on year 6, but the racket ended on year 5.
That is so, Chairperson, yes.
Yes, then you deal with the U.S. case law. I mean, one of the things, you can comment on this if you want, but just want to mention it, that one of the things that I found about this report is that it does not refer to South African case law. It refers to American case law.
Chairperson, when South African prosecutors were trained on racketeering, as it is a concept that originated in the USA, we had Michael Johnson from the USA who came to sort of lecture us on the development of the law in the USA relating to racketeering.
Yes.
So most of us would refer to US case law with respect to racketeering, which most of us think is is much more in line with the legal framework that we have here. Them having a Bill of Rights with us with a Bill of... The framework is more or less the same.
Yes, well, there's South African case law, constitutional court case law, that says actually the wording is different. So one needs to look at South African cases.
You started home first.
Yes.
Before you go to the USA, yes.
But the point is the total absence of South African case law from this report, like zero. No South African case is referred to at all in relation to the requirements of poker.
That is quite surprising that no reference would be made to the Constitutional Court and the SCA's decisions, which we have in this country. Yes.
Now, it seems also from what you are saying in your statement at 462 that even the U.S. case law is misconceived.
That is so, Chairperson.
Can you just deal with that?
I also emphasize the report's reliance on U.S. case law is misconceived. If one looks at HJ Incorporated versus Northwest Bell Telephone CO, the U.S. Supreme Court held that continuity is both a close and open-ended concept, referring to either to a close period of repeated conduct or to past conduct that, by virtue of its nature, projects into the future with a threat of repetition. Continuity can thus be established by proving racketeering acts that themselves include specific threat of extending indefinitely into the future, or predicate acts or offenses that are part of an ongoing entity's regular way of doing business. The court further noted that the continuity requirement is likewise satisfied when it is shown that the predicates are a regular way of conducting the defendant's ongoing legitimate business.
Yes, well, although in this case that wouldn't be applicable. It's never legitimate to torture suspects and to kill suspects.
That is so, Chairperson. It can never be lawful to conduct business in that way.
And then 462.3.
462.3. This misunderstanding of the law leads the authors of the report to attribute undue significance to the fact that there were only 2 charges against the accused for predicate offences occurring in 2011, as opposed to 9 charges in 2008.
Yes. So that's the second misconception of the law.
That is correct.
And then there is a third one at 463.
463. Third, the report assumes that a conviction of a manager under Section 21F of poker requires the manager to have himself committed an underlying predicate offence or participated in a pattern of racketeering activity. But that is not what the Section 21F requires. Again, as the SCA has emphasized, the offence lies in the accused's knowledge that the enterprise is being conducted through a pattern of racketeering activity. The manager himself does not need to be charged with the underlying predicate offence that comprise the enterprise pattern of racketeering activity.
Yes, thank you. And then why is that misdirection important?
Chairperson, it is important because a person in the position of General Boysen should be in a position when something comes to his attention to investigate and to make sure that an illegality which has commenced is not continued with. He should take steps. He should have, the members of the SVC Ketomena unit should have accounted. He should have called them to order and say, gentlemen, what is happening here? The first person has passed on. If we need to bring this person to book, we should do it constitutionally in terms of the book.
Yeah.
But you find them involved in killing 1, 2, 3. It continues unabated because they know that he will protect them.
Yes, I mean, the knowledge of 5 killings, in the context of 28 killings, personal knowledge where a man says, I am personally aware of these 5 killings, would that not be sufficient?
That is very sufficient. But the worst, Chairperson, is a person that approaches court and say, I'm applying for an interdict not to be killed. I mean, it's unlawful to kill, so it should be obvious no one should be killed. Now, when you approach court for an interdict, for an order compelling the police not to kill him, it's extraordinary.
Yes. All right. Then at paragraph 462, I think there you set out precisely in words what you've just said, but maybe you can read it. Maybe it's written more elegantly than you've said it.
Oh, yes.
Or maybe you said it more elegantly than it's written.
I think it would be written more elegant, considering that English is not my forte.
Put a dictionary next to you when you write.
Which paragraph is that?
462, Madam Chair.
462. Is 462 not the one that he read?
Yeah, we
into the
just
record?
dealt with 462.
In its entirety.
464.
464.
Yes.
Chairperson, the next is 464.
Yes.
This misdirection leads the authors to conclude that Major General Boysen could not be charged under Section 21F of POCA because he did not personally participate in a pattern of racketeering activity. Apart from the incorrectness of the latter conclusion, which I address below, it does not matter for purposes of a prosecution under Section 21F whether Boysen committed a predicate offense or was involved in a pattern of racketeering activity. The offense is thus established by evidence that Boysen knew or ought to have known that the Ketomena unit was conducting its affairs through a pattern of racketeering activity.
Yes, no, that's really the point about.
Yes.
General Boysen tells us himself that he was aware of 5 killings.
Yes.
And of course, he was aware of the 6th one because Mr. Mkhize was the deponent in that case.
That is correct.
And then under 21F is then charged for management of it, which is knowledge or ought to have known.
It's sufficient compliance with the POCA legislation.
Yes. Then 465, this is now the 4th misconception of the law.
That is correct, Chairperson. Fourth, the authors wrongly requires proof of predicate offenses that give rise to a specific threat of repetition indefinitely into the future.
No, sorry, I think that is incorrectly duplicated because it's the same 466 and 467. So the 4th should be 468 because you've covered that in item 2 of your analysis. Do you agree with that?
Oh, yes, it is.
So, which means the 4th should really be 468.
Yes. Because 460 and 465 are the same.
Yes, exactly. That's what I'm saying.
Paragraph 468.
Yes.
Fourth, the report incorrectly assumes that the predicate act comprising the pattern of racketeering must arise from more than one incident.
Yes. Now, on that score, the evidence leaders put it to Advocate Nogo that because General Boysen was involved in one incident, I don't understand how they say he was involved in one incident when the evidence establishes more.
Yes.
But assuming that it was that incident of the killing of Mr. Ndimande, where he was then charged with 7 predicate offenses arising from that incident, this is really what this is addressing, isn't it?
That is so, Chairperson.
And what's wrong with that?
Chairperson, if one looks at, strictly speaking, at the definition, whether in fact at one stage we ask whether if one incident makes out four offenses, would you consider the 4 offences as 4 separate incidents? But what we did was we focused, irrespective of whether one incident makes 4 offences or not, we considered the incidents as a separate incident.
Well, the offences arising from one incident as
Yes.
separate offences.
Yes, yes.
Now, that is what you deal with at paragraph 470, where the actual error of the Court panel comes from a Florida case.
That is so,
Yes.
Chairperson.
Can you read that? Into
As
the
versus what?
Yes.
In what it was decided in terms of the Florida RICO statute, which defines a pattern of racketeering as engaging in at least 2 incidents of racketeering conduct that have similar intents, results, accomplices, or methods of commission, or that otherwise are interrelated by distinguishing characteristics and are not isolated incidents.
Yes. So that was what the Florida statute provided. It
Yes.
required 2 incidents.
Yes.
And then you deal with that, the paragraph 470.2 about the federal RICO statute in America.
That is so, Chairperson. There is no requirement under the federal RICO statute that to establish a pattern of racketeering activity, there must be at least 2 predicate acts arising from one incident.
Or more than.
There must be at least 2 predicate acts arising from more than one incident. In the United States versus Anthony Indelicato, the Federal Court of Appeals held that racketeering acts that are not widely separated in time, space, may nonetheless, given other evidence of a threat of continuity, constitute a RICO pattern, and that where the virtual simultaneity of 2 acts suggests that they were related, the timing does not negate the existence of a pattern. Rather, evidence of continuity or threat of continuity will simply have to come from facts external to those 2 acts.
Now, here, what is most interesting, which you don't deal with in your statement, is actually the definition in our law that it does not confine itself, or does it confine itself to an incident, or does it simply refer to an offense in Schedule 1?
It refers to an offense in Schedule 1.
So would it matter then that there were 7 offenses committed in one incident?
It would not necessarily matter that one incident yields out a number of offenses referred to in Schedule 1.
Yes. Now, I mean, the fact that this report, goes to take a provincial law from the U.S., from a Florida, ignores even the federal law, ignores even the South African law. I mean, what does that tell you about the quality of this report?
Well, to say the least, leaves a lot to be desired.
Yes. Then you deal with, we can call this now the 5th misdirection at 472.
Sixth, the report incorrectly criticizes the prosecution for relying on hearsay evidence that would, in its view, be deemed, do I say inadmissible? Admissible due to...
Inadmissible.
Inadmissible due inter alia its alleged lack of probative value. It completely overlooks Section 2(2) of POCA, which provides as follows. The court may hear evidence, including evidence with regard to hearsay, similar facts, or previous convictions relating to offences contemplated in subsection 1, notwithstanding that such evidence might otherwise be inadmissible, provided that such evidence would not render the trial unfair.
Yes, and we dealt with extensively with the failure of the report to engage with the case of Savoy.
That is so, Chairman.
Which places hearsay in context.
Yes.
And then 473.
The report 473, the report also fails to distinguish between admissibility of hearsay evidence on racketeering charges and the admissibility of hearsay evidence on the underlying predicate offences.
Yes.
Contrary to what the panel assumes, Section 31C of the Law of Evidence Amendment Act is only applicable to predicate offences.
Yes. So in other words, for the predicate offences, hearsay is an exception. For the racketeering offences, hearsay is the rule.
It is the other
It's
way
the
around.
reverse.
Yes, it's the reverse.
They don't seem to understand.
They don't seem to understand.
Yeah.
But that is ordinarily what happens when you have been out of court for a long time.
Who's been out of court for a long time?
Most of the people in the DCOG report.
Oh.
You get out of touch with the principles when you don't get to court in a long time.
Yes.
Can there be such a justification? I beg your pardon. Can such a justification really be sound
No,
for the advocates who litigate in the court in the Republic of South Africa? And there are decisions in these courts, that addresses the very, very pieces of legislation they are working under.
Chairperson, it's inconceivable. It cannot be justified. All I'm saying is that the more you are in court, the more sharper you become. When you engage with the sharper counsels, you become more sharp. But when you sit in the office and read the reports, then you become more rusty.
Of course, I mean, you go and write a report, you have to do research, you have to apply your mind.
You have to look at the latest
Decisions of the
decisions
courts.
and how the latest interpretations of case law to make sure that your recommendation will be relevant.
Yes, so the fact that you don't go to court often is not excusable, is it?
I follow, Chairperson. Thank you.
Yes. Thank you. So we've given all of the legal critique of the report, and we've also dealt with the facts that if they just excluded 12 of the reports from their assessment, of the dockets from their assessment for unexplained reasons.
Yes.
Yes. I mean, you obviously wouldn't have insight into how exactly they went about doing their work because you're not part of them.
That is correct, Chairperson. But if even at the towards the completion of the report, they would have They would have invited our views. Then at least, because all that you do is just Audi. If you Audi, you are perfect. But if you don't Audi, then it shows that you are one-sided. You don't want to hear you don't want to entertain any opposing views.
Yes.
Is the challenge with the DCOG panel itself, is the challenge not on the person who finally makes a decision based on the contents of this very report with all these misconceptions?
Chairperson, you are very correct. Ultimately, the NDPP should have seen that the prosecution team has not been invited for review and invited their view in order to make an informed decision.
Yes,
but the fact that she does not.
Because given Section 179(5), you have a constitutional duty to act, to be constitutionally compliant.
To be compliant
as the head
and to...
of the institutions such as the NPA.
That is correct, Chairperson.
Thank you, Madam Chair. I want to move on then, Ms. Advocate Maema. We've dealt with what I've classified as the merits of this case,
Yes.
which is presenting the evidence and dealing with the critique. What we haven't dealt with is the chronological sequence, which is in your statement, Part C, from paragraph 396. So might I ask you to go to that portion of your statement? There will be parts you've already addressed in your, so we can skip those, but I just need to make sure that the panel and yourself are aligned on the chronology of your involvement to the end. And that's called prosecutorial history, Part C.
On Part C, yes.
Yes. Now, you did the investigation. Well, you got involved on the 9th of March, according to what you've testified.
Yes.
You went to Durban in May.
Yes, in
And
May.
you formed the view in June that a prosecution is warranted.
That is correct, Chairperson.
Yes. And then the first thing you did, according to the statement, is a prosecution memorandum on the 15th of August 2012, which is annexed as GSM 75. Correct? Are you the person who actually typed up this prosecution memorandum?
That is correct, Chairperson.
We've been talking a lot about this memorandum. We've
Yes.
never identified its author.
No, I am the person who actually typed it up.
Yes. So how was this done? Was it done in collaboration with the prosecution team?
It was done in collaboration with the entire prosecution team.
Yes.
We sat in the boardroom in the DPP office in South Gauteng, and we exchanged views, and I was the one who was typing, and then ultimately when the document is in draft form, it's circulated among the team members who then make contributions, come together again and debate and bounce our ideas until a prosecution memo was produced, until an indictment was produced.
Yes. Then in 398, you set out the briefings that you held. Is that correct? That those are the meetings you held?
That is correct, Chairperson. Those are the meetings that we had with the acting NDPP on the 15th of May 2012, 23rd of May 2012, 12th of June 2012, 9th of July 2012, as well as the 6th of August 2012.
Yes, and that is Advocate Andrew Chauke.
That is correct, Chairperson.
Now, in 399, you already testified about the extensive meetings you had around the definition of the word enterprise.
That is correct, as the prosecution team.
Yes.
Yes.
Is that what is referred to at 399?
Yes, Chairperson. During June 2012, senior prosecutors within the NPA engaged in internal deliberations regarding the proper formulation of the enterprise for purposes of contemplated racketeering charges arising from the activities of the Ketomena unit. It was recognized that the earlier drafts of the indictment may have inaccurately treated Ketomena as a standalone organized crime unit or legal entity, whereas the prevailing understanding was that Ketomena functioned at most as a section within the broader Durban or provincial organized crime structures. There was ongoing uncertainty as to whether the provincial organized crime constituted a discrete unit on its own or merely a coordinating function at provincial level. The prosecutors accordingly debated whether the enterprise should be framed as a legal entity, as a legally established entity such as the SAPS, or a component thereof, or as a group of individuals associated in fact. Particularly in light of evidence that members outside Ketomena and other organized crime units were involved in the relevant taxi violence matters. It was agreed that further factual clarification of the command and reporting structures within the SAPS organized crime, including the role of senior management, was required before finalizing the enterprise description, as this formulation was regarded as a critical foundation for the racketeering prosecution. The email correspondence is attached here to marked Annexure GSM 76.
And that's the email at 1A781.
I am there, Chairperson.
Would that be the exchange, the kind of exchange of emails that you would have had trying to work out what the enterprise is, what is the scope of the enterprise?
That is correct, Chairperson, because we would debate, compile, and then circulate. So those were the some of the engagements that we had.
Yes. I mean, forgive me for saying it, but it appears that you've done sort of an extensive intellectual work to get to where you are on this case.
That is correct,
I
Chairperson.
just look at the size of your prosecution memorandum, at the size of your indictment. I just shiver because it's mammoth what you've done. And then someone comes in years later and they say, no, you were all driven by
Ulterior motive.
an ulterior motive. How do you respond to that?
Chairperson, it is disheartening to say the least, but I said yesterday I did not have the powers that the national director has, but it comes with the territory. You are the boss, then your word is the decision of the institution. But at least all I'm saying, Chairperson, I'm not saying I'm absolutely correct, and it would have been my task to go before the court and convince the court. But all I'm saying is, when you take a decision, just hear the other side.
Yes. No, but what I mean is, Advocate Maema, I think many of us have been in practice for a while. If you are on an agenda, that's why there is a procedure of Rule 53.
Review.
Yes, because it produces the record.
Yes.
The agenda will show where Mr. Maema is talking to Mr. Chauke and they are saying, let's just nail Boysen, whatever, even if there is no evidence. What I find unique in what you have been producing as evidence is that consistently over time your focus is on whether the evidence exists or doesn't exist, and internally you disagree about the scope of the enterprise, but you're applying your mind to the law and the facts.
That is correct.
Not a shred of evidence is about anything external.
That is correct. All that we focus on, contents of the dockets, the facts, the hierarchy of command in KZN. We look, we were focused. We were focused on the ball. We were never distracted.
Yes. And I waited to see in the documents the NPA would produce here where the evidence would be found, because this would have been in the background material. And up until now, thousands of pages have been produced. There's not a single word that shows that you strayed out of your mandate.
Chairperson, we really focused. We did our work, and all that we waited for. The matter was in court. We just wanted to go to court and present the evidence, which we were prevented from doing.
Yes. Now, you then move, you've told us these are the internal, because we asked you to produce the internal conversations.
Yes.
Precisely to deal with this idea that there was something untoward here.
Yes.
You produced them, we've shown them to the panel.
Yes.
Are you aware of any of this source of this political innuendo that's been directed your way?
I'm not aware at all. I'm also looking forward to see where it comes from. Because we said we looked at the dockets just as the policy and the law requires to do so.
Yes. Now, you've moved on now from paragraph 399, 400, and 401, and that's still your internal debates at the time.
Yes.
Yes. And then you've dealt with the statement of Eya, why, even though Eya was formerly in charge of the SVC of Kaitomani, in reality, Mr. Boysen was the person de facto in control.
That is correct.
I don't want you to repeat that. And then 404 is something you haven't testified about. Can you just deal with that, because it's featured in this case? And maybe let me take you to the page specifically. This is GSM 77. At page 1A783.
And the chairperson?
Do you recognize that document?
Yes, I do recognize the document.
What is it?
It is a covering letter from the acting DPP in KwaZulu-Natal, Advocate Noko, as she was, Noko Mashilo then, addressed to the acting National Director, Advocate Jiba, requesting for the issuing of racketeering authorizations.
I understand, but you see, the thing that was being discussed is around the signature.
Oh, yes.
And the fact that that arrow there indicates PP or doesn't indicate PP, and whether Advocate Noko actually signed this letter or whether it was signed by Advocate Chauke, and what were the circumstances in this.
All right.
So that's what I want you to explain to the panel.
All right. Now, Chairperson, the document was drafted by the prosecution team. This
Yes.
document was drafted by the prosecution team in the Joburg office of the DPP. It was I compiled it on my laptop on a letterhead of the DPP of K of KwaZulu-Natal. And as this was a high-profile matter, it had to go under the name of the DPP. Although myself as a deputy could sign on behalf of the DPP, but I felt here the national director must see that it is done with the acquiescence of the DPP. So it was drafted in the name of Advocate Mwiponi Noku, who was at the time the acting DPP of KZN. And then what I did then was I would then have had a telephonic arrangement with her to plan to travel to KZN to come and brief her on the documents, on the covering sheet, as well as the prosecution memo. Then what happened then was, as a result of the conversation that I had with her, and I assume that there was a conversation as well between Advocate Mwiponi Noko as well as Advocate Chauke, I was directed to present the documents to Advocate Chauke, who then signed on behalf of Advocate Mwiponi Noko. So it's a document that we drafted in the name of the DPP in KZN, but as a result of the discussion that we had, and the fact that we have a DPP in the South Gauteng office where we were, a discussion between Advocate Mwiponi Noko and Advocate Chauke led to Advocate Chauke then signing on behalf of Advocate Noko, and the documents having been signed, then I then proceeded to take them to Advocate Mosing at head office to be presented to Advocate Jiba.
So the reason I'm asking you is that because this letter has been used now as evidence of Advocate Chauke making procedural decisions outside of his jurisdiction. Now, there's quite a lot of legal arguments. Don't focus on it, just get us the facts. I mean, whose decision was it that an application for a racketeering authorization must be issued, which is contained in this document?
The decision of the prosecutors.
Yes. Of yourselves?
It's my decision and the prosecution team. Yes. Advocate Chauke was never involved. All that he was involved in was the communication of the decision that we made. Because it had to be communicated. Protocol in terms of the NPA, only DPPs communicate with the NDPP. Yes. So myself as a deputy, it is proper that a DPP should sign that communication, not a deputy.
Yes. Now, it looks like in paragraph 3, the accused had already appeared in court. Now, that could give the impression that they appeared charged with racketeering, but before racketeering could be issued. So just explain that. Yeah.
Yes. What happened was when they appeared on the on the 24th of August, and on earlier dates, they were just appearing on the predicate offences. But we made sure that when the matter is transferred to the Durban High Court, the racketeering authorizations are in place.
Yes. Now, you dealt with this this particular document in an email which is at which is at page 1A784. It's actually a long exchange of emails. They start at .786 and they seem to go up. So if you can just take us through the sequence of those emails. With the date and the content of email, and then take us through. I think there's probably about 5 email exchanges.
Chairperson, it was exchanges between the members of the prosecution team on the 14th of August 2012 at 14:21.
At 4:21.
At 04:21.
And just tell us which page you draw that from so that we keep up with you.
Oh yes. Chairperson, I'm at page 1A-785. It's an email from Advocate Anthony Mosing on 14th of August 2012 at 4:21 in the afternoon. It is addressed to Matlubi Ntakaza, a member of the prosecution team, as well as myself. It is from Advocate Anthony Mosing, who was head of special projects in the Office of the National Director. The subject, final Ketomena indictment as modified by Advocate K.R. Matenjwa, who was also a member of the prosecution team. Colleagues, herewith more corrections to the summary of facts and the memorandum. Regards. So Advocate we had sent drafts to Advocate Mosing, and he was then commenting on the proposed corrections that were intended to be considered in respect of both the summary of facts in the indictment as well as the prosecution memorandum. On the 15th of August at 8:30, Advocate Matlubin Tlakaza, who's a member of the team, was writing to the team members, Advocate Matenjwa, Advocate Mlojwa, Jabulani Mlojwa this time, Advocate Patience Muleko, Advocate Pumeza Fuchani, and Lizzie Maputa, who was the PA to Advocate Matenjwa. I was copied. Subject, final Ketomena indictment as modified by Advocate Matenjwa. So what happens is Advocate Matenjwa here makes his written input. These are minor changes on the enterprise only. I think from this we can get our certificates. I'm not sure whether Advocate Maema has printed the hard copies. I'll be at the Constitutional Court today. But what he did was he sent his inputs on the documents, either on the prosecution memo, but I see here he was focusing on the enterprise. So what you do is a document has been drafted, it's circulated, and whoever makes inputs then would make their inputs in color in the documents that he has received. And Mr. Matlubi Ntlakaza, Advocate Matlubi Ntlakaza, made valuable contributions to the development of the prosecution memo. Chairperson, on the 15th of August in 2012 at 12:02 in the afternoon. It's myself, Sello Maema, sending an email to Advocate Mosing, Advocate Matenjo, the deputies. I have them separated there, and the other team members, Advocate Ntlakaza, Advocate Mlochwa, Advocate Moleko, and Advocate Fuchani. Subject: final Ketomena indictments as modified by Advocate Matenjo. Dear colleagues, Anthony, referring to Advocate Mosing, Anthony, I took a look at the proposed changes. It is more to complete the participants in the enterprise, to include the Potcepsen organized crime accused. I have worked it into the indictment at the whereas, at the summary of the substantial facts, and into the prosecution memo. You ask whether we are not repeating the same paragraph at the summary of the case in the prosecution memo. I think it completes the introduction well, and it is not necessarily a repetition, although it has been mentioned in the introductory part. We have also added Lockham and Van Donder as managers of the enterprise. I will make contact with you today or tomorrow to bring hard copies. I've also done the prosecution memo on the KZN letterhead, although our DPP our DPP will sign as arranged with the acting DPP KZN. So when I say our DPP, I was referring to Advocate Chauke, who would sign as it was arranged with the acting DPP in KZN. Thank you for your valuable contribution. We await your facilitation for approval of the racketeering certificates. Remember, we require them next week. We apologize for putting you under pressure. Kind regards, GS Maema. I think when I said we need them next week, we were going to court in the next week. So we would have appreciated to receive the racketeering certificates when we are in the court in the ensuing week.
This email particularly discloses at the time that you yourself have drafted the letter and made a decision to do it in the name of Advocate Noko.
That is correct.
And that Advocate Chauke would sign as arranged.
Yes.
So, does that explain then this document that has a big issue has been made out of, which is the fact that Advocate Chauke has PP'd it with the arrow? That is its source.
Chairperson, he had PP'd it because we anticipated we were going to court the next week.
Yes.
Otherwise, what would have happened is that I would then have to carry all these documents, travel to KZN, wait for the DPP, and then engage with the DPP there. When we have a DPP in the South Gauteng office, it was more for convenience that Advocate Chauke signs, and then it gets transmitted to the National Director.
So when I cross-examined Advocate Nok on this, she said, look, at the time, I was not even fully familiar with the facts of this case because I had just started.
That is correct, yes.
Yes. Was that a factor?
That was a factor. The person who was more fully conversant, to whom most of the reports were done with, was Advocate Chauke.
Yes. Thank you. So that's what you are covering in paragraph 404, is to explain that this was PP'd, but it was my decision. And
yes.
These are the reasons I took the decision.
That is so, Chairperson.
You've now produced the original evidence of this.
That is correct, Chairperson.
Yes. Then, paragraph 405, you deal with this matter being raised with Advocate Mosing.
Chairperson, when the matter was subsequently raised with Advocate Mosing, he advised that the request for racketeering authorization was required to emanate formally from the DPP KwaZulu-Natal. Advocate Mosing thereafter addressed a memorandum to the acting NDPP explaining that the initial transmission had been made in error, attaching a corrected cover letter signed by the then DPP of KwaZulu-Natal, Advocate Noko. The corrected cover letter constituted the operative request. The underlying prosecution memo and the draft indictment, which reflected the collective evidential assessment of the prosecution team, were signed by me as the responsible prosecutor and remained unchanged. A copy of Advocate Musing's memorandum is attached as GSM 79.
Now that you will find at 1A787.
That is correct, Chair. It is marked GSM 79 in red.
Yes.
That's where Advocate Musing then
Just read what he says there, because again, a lot has been made of this, but it's actually all easily explainable.
yes. Chairperson, it bears a stamp of the 27th of August 2012 of the Office of the National Director. It's from Advocate Musing to Advocate N. Jiba, the acting NDPP, subject the state versus Boysen and others. It is dated the 27th of August 2012. Application for directive in terms of Section 111 of Act 51 of 1977 as amended in Sections 44 and read with Section 22(3) of Act 32 of 1998. Dear Advocate Jiba, a directive in respect of the above-mentioned provisions have already been approved and signed by you in the above matter in respect of offences committed within the area of jurisdiction of the DPP Northwest. However, the application was erroneously submitted under the cover of the letter from the DPP South Gauteng instead of the DPP KZN. A new request has now been submitted under cover of the attached letter from the DPP KZN dated the 20th of August 2012. It is requested that the acting national director issue a new centralization directive as per attached draft. It is noted that the consent from Advocate Smith SC is directed to the DPP KZN. The facts are otherwise unchanged. The omission is regretted. Kind regards, Advocate A. Mosing, Head of Special Prosecutions in the Office of the National Director.
Yes. Now, when the error was admitted at the time, not even, it's like within a couple of days, they say, look, we made a mistake, please change this.
Yes.
What's the problem with this? Why is the current NDP, she's now gone. Why was she worried about this?
It shouldn't even have been an issue. The error was realized and it was corrected.
Yes.
So I don't see why there is any issue.
And the error would have been made by yourself.
That is so.
Yes.
And then I then realized that it must be, the request must be issued on the correct letterhead.
Yes.
And
then when that was issued, it was signed.
yes, when that was issued, then it was signed. Yes. It was signed on the Racketeering authorizations were signed on the 16th of August.
Yes. Now, then we've got paragraph 406. But that's the contents of the memorandum.
That is
which
correct.
We've been dealing with extensively, so we don't have to deal with that.
Yes.
It goes on to identify the accused at 412. We don't have to deal with that. And 413 and 414. Yes. So up to 417. That is the summary of the Racketeering prosecution memorandum.
That is correct,
Yes.
Chairperson.
You confirm that that's correct, it's consistent with the memorandum.
I confirm it is consistent with the memorandum and it is correct.
Now, then we have a scenario on the chronology in which Advocate Jiba is no longer the NDPP, acting NDPP.
That is correct.
Can you just explain how that transpired?
I'm just checking whether I deal with it in the.
No, you
affidavit?
don't deal with it, but as I understand, the acting period ended, and then a new NDPP was appointed.
I think Mr. Ngasana was then appointed as NDPP, and he would then commence, I think in October. He was appointed, his appointment was announced, but he would then commence a month or two thereafter.
Yes, you deal with that at 420 of your statement.
That is so, Chairperson. It is apposite to mention that Advocate Ngasana was appointed as NDPP not long before the Gauteng J judgment was delivered on 26 February 2014. His appointment was announced on 1 August 2013, and it was effective from 1 October 2013.
Yes, and then 421.
421, given that Mr. Ngasana was newly appointed, the prosecution team prepared a memorandum dated the 5th of March 2014 in order to enable Advocate Chauke to brief the NDPP.
So this is now after the judgment of Judge Gauteng was given.
That is correct.
Yes, we've also dealt in this inquiry a lot with the judgment of Judge Gauteng, so I'm not going to waste your time to analyze it. Yes. So it comes on the 26th of February 2014, and then on the 5th of March, that's where you step in.
Yes.
All right, and then what happens after?
Given that Mr. Ngasana was newly appointed, the prosecution team prepared a memorandum on the 5th of March 2014 in order to enable Advocate Chauke to brief the NDPP. We advised Advocate Chauke that based on the concessions made by Advocate Hodes SC, the team's view was that the judgment should not be appealed, given that the court did not foreclose the door on the NPA to reissue the POCA certificates.
Yes, let's just go to your memorandum that you wrote, which is GSM 82.
I am there, Chairperson, at 1A 799.
18799. What is this document?
Chairperson, it is a document from the prosecution team directed to the DPP South Gauteng, Mr. Chauke, where we then deal with the way forward, having received the Gauteng J judgment.
Yes. What is the purpose of that document under Section A?
Under Section A, the purpose of this memorandum is to update the National Director of Public Prosecutions and the head of NPAs following the judgment delivered by Gauteng J of KwaZulu-Natal High Court on the 26th of February 2014. The judgment is attached as Annexure A and the indictment attached as Annexure B. The prosecution team also seeks to inform the National Director of our intended course of action in the light of this judgment. At paragraph B, we dealt with the judgment of Gauteng J as he then was. 3. In terms of paragraph 37 of the judgment, the applicant, Mr. Boysen, was granted prayers A, B, C, and D. In paragraph 40, the applicant was unsuccessful in respect of prayer E of the notice of motion. In effect, this meant that the authorization issued by the acting National Director of Public Prosecutions on 17 August for the prosecution of the applicant on the racketeering charges and the decision to prosecute the applicant on the predicate offences count 8 to 12 was set aside. The applicant had also sought to interdict the National Director from issuing new authorizations in respect of prayer E. The court dealt with in paragraph 40 of the judgment, and the court found that making such an order would amount to fettering on the discretion of the NDPP to make the decision in question. The applicant thus failed in this respect. The prosecution team intends to reapply for the racketeering authorizations as soon as possible.
just hold in there, Here again, you are explaining to the reader that it is your decision to reapply for fresh racketeering authorizations.
That is so. Our decision as a prosecution team.
You know that Advocate Chauke is charged with that here in this inquiry.
It's surprising because the NPA knows who did that decision. The decision was that of the prosecution team, which I led.
Yes. But you said so in writing as early as the 5th of March 2014 as well.
That is correct, Chairperson, yes.
Carry on, and then the reasons that are given for the decision that you have made to reapply for the reissuance of the racketeering certificates are from paragraph 5. What do you say, the prosecution's team's view of the judgment?
The prosecution team's view of the judgment at paragraph 5. Outside counsel were briefed by the state attorney, namely Advocate Hodes SC and Advocate Managa, to represent the acting NDPP. At this stage, the team has not yet met with outside counsel who argued the matter in order to incorporate their views on the matter. Paragraph 6. The prosecution team, however, is of the view that there were crucial concessions which were incorrectly made by counsel during his argument. And we refer see paragraph 29 of the judgment. Paragraph 7. The concession in paragraph 29 was that there are no statements in the docket which implicated the applicant in any of these offences with which he has been charged. This was an incorrect concession, as there are statements that implicate the applicant in the dockets. For instance, the Howie case 106 of 9 of 2008. The applicant arrived at the scene in a helicopter and congratulated the members who fired shots for the job very well done. In this matter, it appears that the applicant was informing the tracing unit of the whereabouts of the deceased, which resulted in the deceased being located on the N3. This is made clear by the motivation for the monetary awards, which was submitted by the applicant.
This is what we considered on day 2 of your evidence.
That is correct.
The monetary awards document of the 15th of October 2008.
That is correct. Yeah.
Yes. Now, just your comment on the concession. Now, Advocate Hodes, we consulted with him, and as far as I know, he's still a keen witness for this panel. Says he never made this concession, and he even produced the transcript of the exchange in court, which doesn't show that there was any concession made. Were you in court when the matter was argued?
Advocate Chauke was in court when the matter was argued.
I'm asking you.
I was not in court.
Oh, I see. So you wouldn't have personal knowledge of whether the concession was made or not?
Yes, but I agree that Advocate Hodes went to an extent of having the transcript of the argument transcribed and furnished us with it.
He also gave it to you?
He also gave me a copy. I have a copy.
And you read it?
I read it, and I was convinced that no such concession was made.
But when you wrote the memorandum, you were basing it on the recordal of the concession in the judgment?
That is correct, Chairperson. Yes.
Thank you. Yes, carry on with paragraph...
Paragraph 8.
Yes.
The prosecution team had empowered counsel with copies of the statements on which the acting NDPP based her decision. The court was, however, not favoured with the copies of these copies. Instead, concessions which had the effect of discrediting the rationality of the decision were made. The copies of the relevant statement in the docket and 2 memoranda dated 4 June 2013 and 15 August 2013 in response to the applicant's papers were provided. See Annexure C and Annexure D are attached here too. Paragraph 9. The prosecution team was also not favoured with the affidavits prepared by counsel on behalf of the acting NDPP to enable the team to correct or add the facts which could have been lacking. For example, the deafening silence referred to by the judge in respect of the allegations of mendacity made by the applicant dealt with in paragraph 34 of the judgment. 10. We feel, therefore, that the concessions were incorrectly made. This is the aspect which informs us that it is undesirable to appeal this matter. 11, in terms of process, since we do not intend to appeal the judgment, we have the view that we should call upon the applicant to appear before the High Court to formally withdraw the charges in the meantime, pending an intended application to USE for a new authorization.
Yes. So, I mean, as I understand, your view at the time was, let's not appeal, but let's proceed with charging all of the accused.
That is correct.
Yes.
As we are confident and sure that we have sufficient evidence justifying all the charges.
Yes. And it doesn't appear here that you were of the view that any further investigations had to be conducted. The evidence you had, you believed was sufficient.
Chairperson, what happens with the criminal case is you continue with it until, and even after conviction, you continue. So even though you would hold the view that there is sufficient evidence to amount to a prima facie case, but the investigation continues until the matter is finalized.
Yes, but I mean, this is not one of those cases where one says, because it doesn't appear from your memorandum, where one says, okay, well, I am missing a witness that is crucial to complete an aspect of an element of a crime. Here you believed you had all of the right witnesses, all of the right evidence to prove your entire crime.
That is correct, Chairperson. We are convinced that we ticked all the boxes.
Yes, yes. And the sir that's referred to here is Advocate Masan.
Say again, Chairperson.
When you say we will...
Oh, the say, yes. Oh, yes, the say.
We intend applying to you, sir.
Yes,
that's Advocate Masan.
That is Advocate.
Yes.
That is Mr. Masan.
Mr. Masan, yes.
Yes.
Okay. Then you deal with that under C.
C, re-application for authorization certificate. 12, the prosecution team intends to apply to the NDPP for the reissuing of the certificate. We shall prepare a new memorandum which outlines in detail the evidence against the applicant. 13, we are still firmly of a strong view that there are sufficient facts which justify the reissuing of a racketeering authorization.
Yes. And again, this is the whole point now that's been put on Mr. Chauke, when it's so clear that you said you are the ones who are of the strong view that new certificates must be issued.
Sadly,
on the same facts.
But what I'm saying is, sadly, that it should be attributed to Advocate Chauke when the NPA knows who made those decisions. It is us, the prosecution team.
Yes. Now, once you wrote that memorandum in which you said, instead of appealing, a better thing to do is to reissue on the same facts.
Yes.
You then, at 422 of your statement, then met with Advocate Hodes. Is that correct?
That is.
Counsel, before you go to the next paragraph, 422, we propose to take a short break until past. We would have 30 minutes to complete the day when you come back.
Thank you, Madam Chair.
We'll adjourn for 10 minutes until past, and remember you are under oath.
That is correct, Chair.
Good afternoon. Good afternoon, Advocate Maema.
Good afternoon,
Advocate,
Chairperson.
Chauke. You may proceed, Advocate Ngcukaitobi. You continue to be under oath, Advocate Maema.
That
you
is
will
correct,
proceed
Chairperson.
until 5 o'clock.
Thank you, Madam Chair. I need to just complete the motivation for the issuance of new racketeering certificates at 1A/801. Are you still there?
I'm still here, Chairperson.
Yeah. Now, remember, you've given evidence just before we broke that this is your decision. You can't follow why Advocate Chauke is charged with it, correct?
Indeed, Chairperson.
Now, there is, if you look at the part that should be a signature, this is unsigned. It says National Prosecution Team, Director of Public Prosecutions, South Gauteng High Court, Johannesburg. What is going on there?
Well, the memo is the letter. The memo comes from the National Prosecution Team, which are based or which are working from the DPP office in South Gauteng. That's all it means.
Okay, I see.
But the document that was submitted was signed.
Yeah.
Yes.
By yourself.
But it was signed by my. I was signing all the documents out of the prosecution.
Yes. So the fact that it says Director of Public Prosecutions, South Gauteng High Court, as the author of it, does not mean he wrote it.
Not at all. No, he didn't write it. It was written by the prosecution team.
Yes.
Yes.
Thank you. Now, you then go back. You've done this motivation to the Advocate Ngasana.
Yes.
You say, look, we are worried about this concession. If it has been made, we have no case on appeal.
Yes.
Yes. Then at 422, you go back to consult with Advocate Hodes, SC.
That is correct.
Just take us through that.
The prosecution team consulted with Advocate Hodes SC with regard to the concession referred to in the judgment. On the 13th March 2014, during such consultation, Hodes SC advised us that he did not make that. He did not make the confession referred to in the judgment. He also offered to have the recordings of the hearing transcribed. However, paragraph 23, however, whilst the NPA was properly considering its position to prevent the lapsing of the DS in DQI, the prosecution team and Advocate Chauke instructed the state attorney and Hodes SC to prepare an application for leave to appeal and to have it delivered urgently. Advocate Chauke undertook to brief the national office of the decision to appeal the matter. The application for leave to appeal is dated the 16th of March 2014, and I attach a copy thereto marked GSM 83.
Yes, now this is also one of the issues that are being put at the door of Advocate Chauke, the decision to institute a leave to appeal.
Yes.
Yes. Now, your memorandum was that we should not appeal.
Yes.
And it is dated, as I recall, on the 5th of March, 2014.
That is correct, Chairperson.
And the leave to appeal is submitted on the 16th of March.
That is correct.
And that's in relation to a judgment of the 26th of March.
Yes.
So this is very, very close, if not exactly on the 15th day.
It is very close to this to the 15th day, which is allowed to file a notice of appeal without filing a condonation application.
Yes, after the 15th day, what happens if you have not appealed?
And you'll have to, together with your application for leave to appeal, file a condonation.
And if your condonation is refused because you don't have a good reason?
Then, quite sure,
Yes.
matter ends.
Yes. Now, I just want to go back to the discussion then, because your view is no appeal, but there is the risk that the DS is lapsing.
Yes.
What actually happened there? Just enlighten us.
What we did was we just held the view that perhaps let's just file a notice of appeal we know that it has to be filed in the name of the national director, and we knew that we had to bring him on board. But we felt we might not have the luxury of time. The DS in due care might lapse on us, and we might just have to file a condonation application. So we decided, let's file this leave to appeal. If he decides not in his name, then we just withdraw it.
Now, at this point, I want to remind you of your letter of delegation that you had received right at the outset on the 9th of March 2012. Did it include the authority to institute a leave to appeal?
It expressly included the authority to file an appeal.
Yes. And whose decision here was it that a leave to appeal must be instituted?
It was our decision, the prosecution team, with the exclusion of Advocate Chauke.
Yes. But he was still mandated to approach the state attorney.
Chairperson, as the the leader in the office, it was we thought it appropriate to ask him to approach the state attorney.
Yes. No, I understand. I mean, that's what you decided, but
Yes.
the question is one of authority. You have the authority because you've been given it expressly by
But the
Advocate
delegation,
Jiba.
yes,
Yes. It says it includes the power to appeal
it does.
and to oppose an appeal.
That is correct.
Yes. And then you say to Advocate Chauke, I've decided we should appeal this. Please tell the state attorney.
Yes, because institutionally, the DPP is the one who does those communications.
Yes. Then the leave to appeal, it's GSM 83, which is at page
1A-802.
1A-802, yes. If you could take us through that, that would be helpful. Not that you should read all of the grounds of appeal, but some of the salient ones, particularly paragraph 1, 2, 3, and 4, and 5. Because that was the central concern you had, why there should be no leave to appeal.
That is so. Chair.
Consulted with Advocate Hodes. And what was his view, by the way? I didn't ask you that question. Advocate Hodes, did he think there was a good prospect, or did he think there was no good prospect?
He thought there was. He was in agreement with the view to appeal. He thought there was a good prospect of success.
Yeah. All right. Carry on then with the grounds for leave to appeal.
The grounds for leave to appeal are the following. Firstly, the learned judge attributed various concessions to the applicant's counsel, which are unfounded by both the argument and the answering affidavit. At no stage was it considered, as held in paragraph 24 of the judgment, that these decisions were subject to judicial review based on the principle of legality. The only concession that was made in argument by the applicant's counsel was that, as contained in paragraph 6 of the judgment, to the effect that this honorable court could have jurisdiction to hear this matter on the basis of the decision of Estate Agents Board versus LEG, 1979, Volume 3, SA 1048A. 2. The applicant's counsel, having made this concession, still submitted that the correct court to determine these issues would be the trial court, and that no basis had been made out for this court to have had this matter at this stage. 3. The submission is borne out by the finding at paragraph 9 of the judgment that a proliferation of applicants brought prior to a criminal trial.
Applications, not applicants.
That a proliferation of applications brought prior to a criminal trial must be discouraged. Additionally, the learned judge held that in this narrow instance, this court was the appropriate forum and that the appropriate procedure had been adopted on the grounds that the issue raised in this matter was to question whether Mr. Boysen can be charged with the 2 poker counts which required a determination of the validity of the issuing of the authorizations, and further that this application related to only one of a number of accused persons, consequently could most conveniently be dealt with in a separate application which did not affect the conduct of the trial. Whereas it is submitted that the trial court would be the best suited to determine this issue at the commencement of the trial, and would then do so in respect of all accused with a view to avoiding a multiplicity or proliferation of such applications. For no basis existed to hold that it appeared to have been accepted that the fate of the second impugned decision must follow that of the first one. They are separate and distinguishable decisions that have their own jurisdictional requirements. 5. No concession was made in argument by the applicant's counsel, and that no statements contained in the docket implicated Boysens in any of the offences with which he has been charged. Nevertheless, at paragraph 29 of the judgment, the learned judge held that the dockets could therefore not have provided a rational basis for arriving at the impugned decision.
Yes, so in the leave to appeal, it was expressly contested that no concession was made by...
That is correct.
Now, the leave to appeal is lengthy. I don't intend to take you there. I wanted to deal only with the issue of the concession.
Yes.
Now, in file 3 of the black file, now you will find this issue of the concession addressed in an extract from the answering affidavit of Advocate Sean Abrahams, starting at page 259. Do you have 259?
I am at 259, Chair.
Yes. If you can skip the pages to 266.
I am at 266, Chair.
Yes. Under Roman figure 2, the heading alleged concessions by Hodes SC.
I can see that, Chairperson.
Now, what did Advocate Abraham say about this alleged concession? Paragraph 164.
Paragraph 164. The applicants herein, in their defense of the decision of Gauteng, place considerable emphasis upon his finding that Jiba's counsel made concessions which they suggest should be considered by this court. 165. But the examination of the transcript suggests that what is characterized as a concession made by Hodes, Jiba's counsel, is at best ambiguous. At first blush, Hodes, in a truncated series of responses to questions from the bench, does appear to concede that there was no evidence in the dockets linking Boysens to the offences. However, in a series of responses shortly thereafter, Hodes qualified his language in a manner that knocks the props from beneath the applicant's case and makes clear that he did not convey what the applicants claim he did. Hodes made it clear that some of the evidence upon which Jiva relied had not been disclosed to Boysen. Jiva had regard to a memorandum from the second respondent, which she wasn't prepared to hand over. There was far more implicating the applicants than just those 4 statements that she referred to. Page 67, lines 2 to 20.
Paragraph 167.
167. Soon thereafter, the following exchanges appear in the transcript. Attached here to SA 10. This is now Gauteng J. An uncontested assertion is made by Boysen that none of that evidence in the docket implicates the applicant. Do you accept it as an uncontested assertion? Mr. Hodes then replies, I accept that it is uncontested, that would be sick, and that it is stated in these papers for the trial court to eventually decide. But I do accept that there is an intervention, page 67, line 25, page 68, line 1 to 5. Paragraph 168, it is somewhat confusing language that is said to constitute a concession that the contents of the docket did not implicate Boysen. 169, Gauteng J followed up with the following question. Yes, that may be so, but uncontested assertion is that statements in the docket don't implicate the applicant, and that the question is whether there is information under oath so that it is what she says she has considered in arriving at the decision. Can there be a rational connection between the decision arrived at and those things? Information under oath and statements in the docket. Page 68, line 6 to 11. At 170, importantly, Hodes answered that there could indeed be a rational connection. I submit that they can, my lord. I accept that it was unchallenged, that in the applicant's view, he is not implicated in the statements in the docket. But what was made clear from the annexures, my lord, is that the entire docket was not finished. Own emphasis added, page 68, lines 12 to 20. 171. Once Hodes had an opportunity to clarify what he had meant, it became clear that his concession was that it was indeed Boysen's case, that Boysen was not implicated in the statements in the docket that had been produced by the NPA. But Hodes was at pains to make clear that Jiba had relied on inculpatory material in parts of the docket that were not produced. This material did link Boysen with the underlying offences. If one has regard to the contents of this paragraph and the sub-paragraphs, it is apparent that the first respondent was of the view that the statements in the docket do in fact implicate the applicants in the commission of the offences. In brackets, page 72, line 17 to 20. 172, Gauteng J was with respect wrong when he wrote, this leaves 4 annexures to the answering affidavit mentioned above. These are the only documents not contained in the dockets on which the NDPP says she based the impugned decision. She says that they are all statements made under oath. Paragraph 3.
Yes, thank you. Now, I mean, if you just go back to the extract from the exchange in court at paragraph 171, where it is quoted that Advocate Hodes said, if one has regard to the content of those paragraphs and the sub-paragraphs, it is apparent that the first respondent was of the view that the statements in the docket do in fact implicate the applicant. The applicant there was Major General Boysen.
Yes.
In the commission of the offences. I mean, can it be said that a person who says the opposite has considered that the docket does not contain statements that implicate the applicant?
It cannot be justified on a mere reading of that section.
Yes. Now, is this the information, or was there any other information that Advocate Hodes presented to you to show that he didn't make the concession that the docket does not implicate Major General Boysen?
Chairperson, what he did was he transcribed the argument and finished us with a copy.
I see.
Yes.
And you could read it for yourselves.
We could read for ourselves. It was typed. You could see that he didn't make that concession.
Yes. Because it seems he actually said the opposite. He said
Yes.
the information in the docket does implicate. Yes.
The applicant, yes.
Now, you are now with your counsel. You've decided, well, we shouldn't appeal, but you thought in order to arrest DS Non, we should appeal, but you have the authority. You get Mr. Chauke to write to the state attorney, correct? Yes. Now, that is what was dealt with at paragraph 423 of your statement. Then at 424, now that the application for leave to appeal has been served, what happens?
Shortly thereafter, Mr. Ngasana then issues an instruction that the application for leave to appeal must be withdrawn. On 26 March 2014, instructions were issued to the state attorney to withdraw the application for leave to appeal.
Yes.
A copy of the email to the state attorney is attached as Annexure GSM 84.
Yes, 84 at page, it's shortly after the leave to appeal, at page 18825.
Yes, 85.
Just before you deal with that, who in fact prepared the leave to appeal? If you look at the email from Estelle on the 17th of March 2014, that is the second email on that same page.
That is correct, on the bottom.
Yes.
Attached, please find final leave to appeal to be served and filed on the 18th of March. Regards, Advocate Lawrence Hodes, ASC. It was counsel himself who prepared the leave to appeal.
Yes. And then the email we were trying to focus on the 26th of March 2014 at 18825. Where is that email from?
The email is from Advocate Chauke. It is sent to Estelle, sent to Nelson Gavenda at justice.gov.za, and then it's sent also to Advocate Muiponino.
Yes. And then what does it say?
Good day, State Attorney Gavenda. On Tuesday, 25 March 2014, the NDPP has decided not to appeal the judgment in the Boysen's matter. Accordingly, the notice of application for leave to appeal must be withdrawn. Kind regards, M.A. Chauke, Director of Prosecutions, South Gauteng.
Yes. And again, when the instructions are coming from you, he is the conduit, but it seems also when they're coming from the top, he is also the conduit.
That is correct.
Yes. It is criticized only in respect of one set of decisions and not the other.
Not the other.
Now, then, once it has now been withdrawn, on the 26th of March 2014, the leave to appeal has been withdrawn, but you are still of the view that fresh certificates must be reissued, correct?
That is correct.
You are then called into a meeting on at paragraph 425,
Yes,
which was on the 7th of April 2014.
that is correct. Yeah.
What happened in that meeting?
The prosecution then was then called into a meeting with Mr. Ngasana to update him on the matter. The meeting was scheduled for 7 April 2014. In preparation for the meeting of 7 April, the prosecution team prepared a PowerPoint presentation with the intention to utilize the presentation for purpose of briefing briefing Advocate Ngasana on the matter. It must be Mr. Ngasana on the matter. 427. In that meeting, Mr. Ngasana informed the prosecution team that in his view, it was unnecessary to appeal the judgment, as paragraph 39 and 40 of Govan J's judgment indicated that the NDPP was not precluded from issuing fresh authorization certificate. He further directed that a prosecution memo be prepared requesting the issuing of authorizations in terms of poker, and advised that once the memorandum was presented, he would recuse himself and delegate his decision-making functions in relation to the matter to Dr. Ramaite.
Now just explain that aspect of it, because the recusal is the first time it's coming in. What was the basis for the recusal?
Well, he indicated that when he was an attorney in Durban, he had appeared for some of the Ketomena members in some of the matters. So it would be he might be conceived not to bring an impartial mind to bear on the merits because he had represented some of them in the past. He then indicated that he would delegate the decision making to his deputy, Dr. Silas Ramaite, at the time.
Yes. But the instruction was that you should proceed with the application for a fresh racketeering certificate.
That is correct, Chairperson.
Yes. Then it seems there's something else he said in that meeting at paragraph 428.
That is so, Chairperson. In that same meeting, Advocate Mr. Ngasana also stated that in view of the fact that Advocate Sempuya Mloja was no longer the acting DPP, Advocate Noko was appointed as DPP of KwaZulu-Natal. There was no longer a need for Advocate Chauke to manage the prosecution team. He was to be removed from his role in the matter.
Was he actually removed, Mr. Chauke?
Yes, he was actually removed in the meeting. And I can remember him standing up in the meeting and leaving the meeting. I was actually sitting next to him. He was on my right.
Yes. And then at paragraph 429,
Advocate Ngasana directed that the full prosecution memorandum be presented by the end of May 2014. The prosecution team prepared a memorandum signed by me, and the application was forwarded by Advocate Noko to Advocate Ngasana on the 4th of June 2014. This memorandum is attached here to marked GSM 85.
yes, so you can have a look at that at 1A 826.
That is correct, Chairperson.
What is that document?
It is the prosecution memo that we prepared through which we are going to seek the reissuing of fresh racketeering authorizations.
And then if you look at where it's signed, which is 1A 837.
That is correct, Chairperson. Then there I sign in my capacity as a Deputy Director of Public Prosecutions.
Yes. And we don't have to go through it. I mean, it's still aligned with your view that there is still a strong case based on the existing evidence. And
That is correct.
New racketeering certificates must be issued.
That is correct.
Yes. Now, this is submitted on the 4th of June. And then a month and a half later, there is an email referenced at paragraph 430. So what was the decision of Advocate Ngasana, now that you've told it that our view is that we should press ahead with the prosecution?
Mr. Ngasana's view was that we should get more information.
Okay. Yes. Can you deal with paragraph 430 of your statement?
Maybe before he proceeds to that paragraph.
Thank you.
Advocate Maema,
Chairperson.
it would appear from this prosecution memo that you sign that Advocate Ngasana, or rather, I beg your pardon, he's my colleague, Attorney Ngasana,
Yes.
did not require the Director of Public Prosecutions of KwaZulu-Natal, whether acting or as a substantive prosecutor, to sign the memo asking for the issuance of the certificates?
That is correct, Chair. He wasn't specific as to who it comes from.
It would be fair to say that it was not necessary.
Yes, it was
for
not necessary.
the prosecutor, the Director of Public Prosecutions, to sign the memo.
That is so.
Thank you.
Yes.
Thank you.
Sorry, as a follow-up, from paragraph 428. No, 427. Mr. Ngasana makes it clear that he might be conflicted. He doesn't want to take that decision.
That is correct, Chair.
And your evidence is that GSM 85 was submitted to Mr. Ngasana when in fact he had already indicated that he will delegate that function to Dr. Ramaite.
That is correct, Chair.
And then Mr. Ngasana comes back to you and says he needs more evidence.
That is
Does that mean that Mr. Ngasana, contrary to what he said, that he will recuse himself, he still considered the prosecution memorandum and made a decision while he knew that there is a potential of a conflict of interest?
Chairperson, what would happen is that in the deliberations that we have with the office of the NDPP, he would be present and he would participate. So what I understood there for him to mean is he would participate in the deliberations, but coming to the signing of the racketeering authorization, he would delegate that function to his deputy Advocate Ramaite. Because then what would happen, it's a decision of the NDPP, but whether it's taken by him or is taken by his deputy, it would still be the decision of the NDPP. But he continued participating in the deliberations, Chairperson.
My question is, how to, on one hand, say I might be conflicted because I've already represented some of the Katomena members, and then I will delegate this function to my deputy, but still continue to participate in the deliberation? Isn't that a way of influencing the direction of the deliberations, especially if you are aware that you are conflicted and you are an officer of the court?
I agree, Chairperson. In a way, it would. Strictly speaking, once he steps down and he says, I'm conflicted, I would have expected him not to be even part of the deliberations, but he continued to become part of he continued as part of the deliberations.
That's bizarre.
I agree, Chairperson, it is.
Do you want to complete this part up to GSM 86? We have to pause.
Madam Chair, yes, we might well pause because we still have a witness that we're told to wait for us. So we just need to complete that as well. And I say it's 3 minutes past 5. So
Yeah.
if we could pause here, that would be appreciated.
So we will pause here at GSM 85 at paragraph 429. Tomorrow you proceed from 4:30.
Thank you, Madam Chair.
Yes, thank you, Advocate Maema. Thank you very much. You are still under oath. You'll proceed tomorrow at 9 o'clock.
That is correct, Chair.
You are still under oath. We'll adjourn until 9 o'clock tomorrow morning.